everybody filled out a request to speak? Yeah, I know. I just want to make sure everybody has, because if you don't want to speak, you can donate your 3 minutes to somebody who
No,
has a lot.
no, we cannot donate no time here.
Oh, so,
No, ma'am.
so when did that happen?
That is at the discretion, that's at the discretion of the Board of County Commissioners meeting at this particular forum. Let me set the record straight so you can hear it from the horse's mouth. By the way, my name is Horace Jones. So you're hearing it from the horse's mouth. Yes, as she stated, it's very, very important that you speak at this meeting. That you speak at this meeting. The chairman and this board, they don't allocate time and minutes like that. That's at the discretion of the other board if they do that, but this board does not. But it's very, very important that you speak at this meeting if it proceeds to that level. So I want to say that for anyone who want to speak on any of the rezonings or cases.
So do you have a time limit here?
Yes, ma'am, we do.
On how long we can speak?
The chairman will let you know that. Yes, ma'am.
That'll be 3 minutes.
The chairman-
3 minutes.
Yes, ma'am.
Just see other planning board meetings, there's on social media, people have said, oh, they allowed me to get donated hours to speak.
Yeah, join up and call to a special meeting. So know what we need, get what the staff, so we know we here.
All right, good morning, everybody. This meeting of the Escambia County Planning Board for October 29th, 2024 is hereby called to order. With 6 members present, we do have a quorum. If you could, just please put your phones on silent as not to disrupt the meeting. And if you could, please stand and join me in the Pledge of Allegiance. All right. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll now entertain a motion to waive the reading of the legal advertisement.
So moved.
Got a
Seconded.
Motion is second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning meeting minutes from the previous meeting dated October 1st have been provided to the board. Are there any additions, deletions, or corrections? If none, I'll entertain a motion to accept the meeting minutes thank you. We got a motion. Do we have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed? All right, motion carries. The rezoning hearing package for October 29th with findings of fact have been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and the legal advertisement into evidence. Do we have a motion?
Second.
Motion and a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. Will the court reporter please swear in members of the staff?
Sure. Raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
All right, and the board has previously qualified staff to offer expert testimony in the area of land use and planning. Do any of the board members have questions regarding their qualifications and ability to offer expert testimony? Okay. At this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners. on rezoning applications. These hearings are quasi-judicial in nature, and quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, the exhibits entered into evidence, and the law. Each individual who wishes to address the planning board must complete a speaker request form and submit it to the planning clerk at the front of the room. These forms are on the table in the back of the room, and you will not be allowed to speak until we receive a completed form. Please note that only those individuals who are present and give testimony on the record at this hearing before the planning board will be allowed to speak at the Board of County Commissioners. No new evidence can be presented at the BCC meeting, therefore all testimony and evidence must be presented here today. The planning board will provide a recommendation for each rezoning request to the Board of County Commission, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the Board of County Commission approves or rejects the recommended order of the planning board. All written or oral communications outside of this hearing with the members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution Number 96-13. As each case is heard, I will ask that any board member who has been involved in ex parte communication to please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent, substantial evidence to the Planning Board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. Condition A, consistent with the comprehensive plan, that the proposed zoning is consistent with the future land use FLU category as prescribed in the Land Development Code, Chapter 3, and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU map amendment transmitted for state agency review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, compatible with the surroundings. All the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. That the uses of any surrounding undeveloped land be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities provided by fair housing law. D, appropriate is spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interests between isolated district and adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree and character that it is in the public interest to allow new uses, density, or intensity in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we will allow staff to briefly present the location and zoning maps and photos of the property. Next, we will hear from the applicant and any witnesses that they may wish to call on. Then we will hear from staff and witnesses they may wish to call. And then we will hear from members of the public who have filled out one of the speaker request forms in the back of the room. There are 2 cases to be heard today. The first rezoning application for consideration is case number Z-2024-11, which requests rezoning of Bellevue Road from LDR, Low Density Residential District, for dwelling units per acre, to MDR, Medium Density Residential District, 10 dwelling units per acre, as requested by Meredith Bush, agent for House of Prayer for All Nations Incorporated, the owner. Members of the board, have there been any ex parte communication between you, the applicant, of the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? Also, please disclose if you are a relative of or a business associate of the applicant or the applicant's agent.
No to all.
No to all?
No to all.
No to all.
No to all.
And no to all.
All right, staff was notice of the hearing sent to all interested parties
Yes, sir.
and was notice of the hearing posted on the subject property.
Yes, sir.
All right. Meredith, are you okay with them presenting the aerials and pictures first? Okay. Staff, if you could please go through the maps and photographs for case Z-2024-16.
Good morning, Board. Caleb McCarty, AIC Planner for Escambia County. This is our location map showing Z 2024-11. It's our 500-foot radius zoning map showing the current zoning of LDR. Our future land use designation of the property is mixed-use suburban. The property is currently vacant, surrounded by some various vacant land and subdivisions right behind the fairgrounds. This is an aerial photograph that actually shows the wetlands around the area. And this is a better view of the aerial of the property, in addition to another aerial there.
Thank you.
This is our advertisement, our public hearing sign that was placed along Bellevue Avenue. Additionally, this is looking north of the subject property along Bellevue. This is looking south across Bellevue from the subject property. Looking west along Bellevue Avenue. This is looking east along Bellevue towards Mobile Highway from the subject property. We also put another public hearing sign on Buckland Drive to the north there. This is looking south onto the rear of the subject property. Looking at the adjacent property from the back side of Bellevue on Buckland. And this is looking east from the back side of the subject property. And this is also looking east from the back side of the property. And this is looking north from the rear of the subject property at the cul-de-sac along Buckland. That concludes our maps and photography for this case.
All right, thank you. At this time, Meredith, I'll have you come forward. We don't need to have you sworn in as you are a lawyer representing your client, but would you please state your full name and address for the record?
Yes, Meredith Bush, 125 East Intendencia, Pensacola, Florida, 32502.
And did you receive a copy of the rezoning hearing package and the findings of facts?
Yes,
And you do understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code.
yes.
All right, you go ahead.
Good morning, members of the board. I appreciate your time today. So you may recall seeing this file before you a couple months ago, back in August, I believe, August 6th, at which point in time you recommended approval to the Board of County Commissioners. The Board of County Commissioners remanded the case back to you for consideration related to stormwater concerns. I can go through the findings again. However, the findings and staff's findings haven't changed since last meeting. Staff recommends approval, and we still have presented the same information that we've met all the requirements of the criteria. To allay some of the fears of the neighborhood, I would remind everyone that apartments are not allowed in MDR. So if you grant the MDR rezoning request, the kind of rumor going around that this is going to be some kind of apartment complex is simply not the case. But also in response to the Board of County Commissioners' directives, our engineer who's present and can speak today met with Joy Blackman, the county engineer, and has met with Matt Skipper, the county drainage engineer. And we're in a position to work together in a collaborative effort to improve the stormwater in the area around the subdivision and in the existing subdivisions. Those specifics would be determined during the design process. There is a pre-application that has been submitted, but one solution could be a combination of the existing stormwater pond that's in the westerly neighboring subdivision with our newly designed stormwater pond. So there's, the idea that the stormwater ponds would be combined, that would provide additional stormwater storage, thereby reducing stormwater discharge to the Bellevue Avenue right-of-way. The county engineer also discussed a project that's in the works, I believe it's in the design phase, which is the expansion of the Hogan Road stormwater pond. So there are proposed projects, and there is a proposed remedy that would help alleviate some of the existing stormwater concerns. While this is not a direct criteria to grant the rezoning, the Board of County Commissioners did remand it back on this basis. So I'm happy to go back through the findings of fact if that's what you would desire. Otherwise, I would have Mr. Fitzpatrick, our engineer, come speak to the stormwater issues in whatever the will of the board is.
Board, do you have any questions for Meredith, or would you like to hear from the engineer that she's brought here today?
I would like to hear from the engineer.
And if, when the engineer is speaking, could we have the wetlands map put up on the board?
All right, and I'll just have you please state your full name and address for the record and have you be sworn in, please.
I'm David Fitzpatrick, 10250 North Palafox Street. It's my office.
All right, do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please proceed.
A couple of weeks ago or a month ago, I met with Joy Blackman, the county engineer, and we talked about just, what's going on in that neighborhood or that area. And mainly the problem, from what I heard from her, is the areas south of the project are experiencing stormwater issues. They are working, the county is, on solutions and expansions of existing stormwater ponds down there. We talked about trying to maybe enlarge the stormwater pond on the property to the west of us and kind of include it in our design. That would help alleviate some of the discharge to Bellevue Avenue. Since all these things were designed and approved, our subdivision will be held to a 100-year storm design criteria, and all the others are designed with 25-year. That took effect in 2014. So it is going to make for a larger stormwater pond and should alleviate some of the issues on Bellevue Avenue.
Anybody have any questions?
David, have you done any additional research? Like, do you have any grade? Have you shot grade yet and done like a survey? Is there any of that done?
No, sir, we haven't.
Yeah, hadn't made it that far. I'm just
County,
curious.
the county has a sort of a contour map that we use that shows the property falling from the north to the south towards Bellevue.
So where's the holding pond for the neighborhood to the west?
Right in the southeast corner of the subdivision, right where the cursor is there. There's a small stormwater pond right there.
And so y'all's thought is to expand that one into y'all's, and is that
Yeah.
kind of what the idea was?
Yes, sir.
Okay, thank you.
Will you explain to the board and myself and the public, what's the difference in capturing stormwater for 25-year flood and 100-year flood storm?
A 25-year storm is somewhere, I can't remember exactly, but somewhere around 8 or 10 inches a day for a 24-hour period. That's the most you'll get in a 24-hour period for a 25-year storm. A 100-year storm is over 13 inches in one day. So we're required to use that, that method nowadays to make sure the ponds are larger than what the older ponds are. So it's quite a bit larger.
Are there any further questions? Okay, thank you very much. Meredith, do you have anything else?
At this time, Walker, oh, excuse me.
Yep.
I'd recommend that the board either vote to have Mr. Fitzpatrick as an expert or not in that field.
Mr. Chair, I make a motion that we accept his testimony as expert.
Second.
I would recommend that Mr. Fitzpatrick explain his credentials
Yeah,
and experience prior to a vote. That's the chair's discretion.
Yeah. All good.
I've been a civil engineer in Pensacola, born and raised here, since probably about the late 90s. So been doing civil engineering work since that time, and probably done hundreds of projects in Escambia County just by itself since the late 90s.
In your PE?
Yes, sir.
And just to add, and staff do concur, we have worked with David on many other projects with the certification, and the county engineer as well. So he has submitted many projects with Escambia County. Even before I got here, David was here.
I'm old.
Do we need anything from, on our side of things, to show proof other than the testimony we were just given?
It's the chair's discretion, but
Okay.
not necessarily.
Okay. All right. Any further questions? All right, we've got a motion and a second. Make David a expert witness.
Yes, and I would
Yeah, if you
clarify
would,
what exactly
based
Mr.
on-
Fitzpatrick is an expert in.
Make a motion based on his testimony and that he be accepted as an expert witness.
Is that good? I'll second.
All right, got a motion and a second. All those in favor, please signify by raising your right hand. Motion carries. All right. Anything else, Meredith?
None at this time.
Okay. All right. Staff will go into your presentation, if you will.
Yes, so our findings, we confirmed our findings from the previous hearing. Nothing's changed from our findings. We found that the request for the rezoning still met all criteria for the rezoning. And that's essentially it. We can go back through the findings if you like, but we did find it still meets the criteria.
All right. Is there any questions for staff from any board member? Well, we've got something like this where it's been remanded on stormwater issues, and we've already approved this, agreeing with staff's findings previously and in agreements with the applicant. I'm a little confused as to what we're looking for here today, or that maybe the board is looking different today than what previously happened in August.
If I may, looking through the packet, they wanted us to review criteria E. So my recommendation would be to just, if we could go over criteria E
Okay.
again, to
Certainly, and
refresh
that
our
is
memories.
That's absolutely correct. Criteria E deals with appropriate for changed or changing conditions. And the Board of County Commissioners recommended back specifically based upon that criteria. From our findings, we showed that the land uses or development conditions within the area surrounding the properties have not changed, and that the development within the area has remained low to medium density residential, and with the request for MDR, the potential uses, densities, and intensities allowed by that district will be compatible with the existing surrounding development patterns. The proposed amendment will not create or contribute to urban sprawl.
These are the same findings that you had before. I think the packet has not changed other than the updated pictures. Is that a correct statement?
That is correct, yes.
Okay, thank you.
If you will remind the board, what's the highest intensity use of MDR that is allowed in the code?
It is single-family residential, very similar to what is zoned right now. No mobile homes, no apartments, those particular things. The primary difference is allowance of the density per acre.
Okay, and the
Current
highest
zone.
use of LDR is,
Yes, single-family residential at 4 dwelling units per acre. The MDR request is single-family dwellings at 10 dwelling units per acre.
all right. Any further questions for staff at this time? All right. At this time, we'll move into comments from the public. And again, if you would like to speak on this case, make sure we got a form filled out. They're in the back of the room. We do need one, a separate one for each case that we hear. So just wanted to give you a heads up. And then again, if you'd like to speak at the Board of County Commission meeting when they see this again, you do have to speak here today. So, all right, at this time, we'll start taking testimony. And if you will, just make sure to please state your full name and address for the record and be sworn in as you come up. So first, we've got David Gibson.
David Gibson, 6008 Yellow Rose Drive, Pensacola, Florida, 32526.
Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. Good morning, gentlemen. Thank you for your time, this opportunity to speak. Where that drainage pond is, I live right to the left of that, right in that second curve there, so I know a lot about what's going on. That's the Rosemont subdivision there. It's Zachary Estates on one side, the property that we're discussing on the right side. And what has happened is we have a tremendous water problem there. I have some pictures that I'd like to enter in as evidence, if we could do that.
All right, if we can pause his time real quick. Board, the speaker is asked to submit into evidence pictures of, I assume, flooding issues that
Yes.
occur in the area. If this is something that y'all would like to accept into evidence to look at, we can certainly entertain that motion. And I believe we can look at the photos before we make that decision. Is that correct? Board, how would y'all like to proceed?
I think we're supposed to ask, these are pictures you've taken?
I've taken.
And you printed them off, and these are from you?
Right,
Okay.
correct, yes, sir.
I'll make a motion to at least review the pictures for now.
We'll look at them real quick and then make a decision. Yes, sir. Appreciate it.
Sir, do you have a date of the photo?
This was right after, these are the most recent.
No, sorry.
These were the most recent pictures, and this was, well, let me take that back. We've had a couple of floods since these pictures, but these were from the hurricane that took place, like 2 days after the hurricane.
So to clarify, this is on Yellow Rose
Yellow
Drive.
Rose Drive.
Okay. and
Right
this
in
is the
front of my
holding
house,
pond.
right next to the catchment pond.
All right, and this is the detention pond on the southeastern corner, correct?
Correct.
Just to clarify.
And again, just one more clarification. What we're seeing is the road is swamped.
It's swamped.
Okay.
And that's after about a day, about a day and a half, actually, of water going down after the Hurricane Sally.
Sally from 2020.
2020.
All right, board,
And we've had other floods since then, but this is, yeah. But if you'll notice the
So-
car there, that tried crossing the gentleman's, or our neighbor's
yes, sir.
lawn,
So let me,
got stuck.
let me get these,
Okay, I'm sorry.
let's
Okay.
get this and then make a
Okay.
decision up here of what we would like to
okay.
do with these before we proceed. Board, is there any action that'd like to be taken and whether or not to put this into evidence or not?
Two things. I mean, we don't have a date stamp, so that's one thing. You know, we can't, and especially if it's taken into evidence. And then on top of it all, yeah, it shows the subject property there, but it's not the ROI. It's all really this other neighborhood. As much as I want to take that in, I'm not comfortable taking that in myself.
I'm kind of in agreement. I think I like the pictures, but I think it needs dates, and I think it needs direction that we're looking. You know, we can't really tell where this is on any adjacent property, so I don't know that it would be good evidence to accept.
I'm the opposite. It tells a story, but it's not I mean, again, we don't know where it is, so I'm okay taking it, but it's not but he doesn't have that, so.
I don't have it set.
I'm good taking it, because it's does definitely show that there's water in the thing. And I guess my opinion is you would almost welcome a development to the east that will clean up the water. So it's actually would be information that would propose that the development to the east would be a good thing, because they're gonna clean up the water that's shedding into their houses or their roads.
I'm good with it as well. I have a question for staff. Is that a dry pond?
I'm uncertain myself. The engineer may be able to reference that. David, you know if it's a dry?
I think it's supposed to be a dry.
Okay, yeah.
And this is the thing, and if I may, we need to be clear, because these things has the potential to be challenged. You stated that this happened after Hurricane Sally.
Yes.
So Hurricane Sally, so you know that was a substantial rain event, and basically, all of Escambia County was really inundated by a great deal of rainfall during that period. So we do want to make qualified this type of evidence that basically that
Okay.
not to negate it, please,
Yeah.
not to negate it at all, because it occurred. But we do want to state that was after a substantial hurricane with a loss of rain.
Yes.
Was
All right,
inundated the whole
so
county.
here's, I'll accept a motion if we've got one, and we can vote on whether or not to accept this or not. I would ask if you do make a motion that that we accept the witness's testimony under oath that it was after Hurricane Sally with the date, and that he's being truthful with his location of where these pictures are. So, or else we'll just continue to move on and let him finish his timeout.
Go ahead.
I'd like to make a motion to accept it with, based on the witness's testimony.
I'll check.
Okay, we've got a motion and a second to accept this into evidence. Is there any further discussion on that? If there is not, all those in favor of accepting this into evidence, please signify by raising your right hand. All those opposed? I'll take that as we'll accept it 4-2. Is that correct, gentlemen? Okay, we've accepted this into evidence. We'll start your time back up, and you may continue.
Thank you. The top picture, if you'll notice the car that's there that tried driving across the gentleman's or the neighbor's yard, got stuck. That's quite frequently happening there. Also, the bottom one is, let me go back to the top one, I'm sorry. That's about 3 foot of water in the deepest spot there. In the bottom one, you can see that water is draining into the catchment pond from the ditch. It's not, the ditch is not, or the pond's not dumping into the ditch. That's been part of the problem there. And so the water is the big issue for us. When Zachary Estates was built on the far west side of our subdivision, there was no consideration of water. We have water being dumped into our subdivision. We've complained about it. The county says that there's no easement, anything that they can do between the two subdivisions. We've complained about other issues with the field. The county had an easement. They came in and have kept that easement cut, which has cut down on some burglaries that have been took place in our neighborhood. A lot of our homes were burglarized. And so the ditch is one of the big problems. When the county filled it in to put sidewalks, they diverted all the water to the north side of Bellevue. And part of the problem there too is, I want to ask the staff and the engineer, did you do a perk test of the ground there? Because there is about a 3 foot, well, maybe like about a 2 foot clay layer there. In fact, there in the bottom corner, or to the east of the property, that's a pond, which is an old clay pit that was mined. And there's about a 2 foot clay layer that is there that keeps the water from perking down. And that's another issue that has been created there. And so, and then Bellevue is a two-lane road. It has become a main thoroughfare. We have tractor trailer trucks 10 to 12 times a day coming down through there, making a shortcut so they don't have to go down to Softly Field and come around. And I know y'all can't address that. It's a traffic issue that we need to take up with another committee. And but I'm glad to hear. Thank you for the clarification that it's going to remain consistent. There'll be no apartments going in there.
Yes, sir. And I'll
That's
just let
helpful.
you wrap up real
Thank you.
quick.
Okay, and that's basically. But I supported the church. I was all for them going in there. It was a real contentious before y'all were probably on the board, and I supported the church. Wanted them to go in there, and they in fact, one of the commissioners talked to me afterwards about that. So that's it. Thank you.
Thank you.
Board, just to clarify an earlier statement, there was a question about the actual pond itself. It's dedicated as a public retention pond. The engineer may be able to speak more, but retention ponds are designed to hold water, from my understanding.
Negative. Can I
No.
address that real quick?
Please.
Yep, the pond does perk, but they had to come back in. I moved into the neighborhood in 2000, and the pond was not perking. When it finally dried up enough that they could get equipment in there, they dug it down past the clay, and you can see it when it's dry. There, you can see where they dug down to make it to where it would perk, but it's not big enough, especially since we're having backflow out of the ditch into the pond. And in this development, if they're going to have the same problem if something's not done with that ditch.
Thank you.
And if I may, I know you may have many questions, but we do want to state again, that from the record, we want to be clear that with the DRC process, if this proceeds, these things will be evaluated extremely carefully and closely by our engineering team. Mr. Fitzpatrick already basically talked about, he already had discussions on that particular issue. Please let me finish. But I just don't want people to understand that there is, if it's approved, there's another process where all of the gentlemen, perk tests, all those things will have to come doing that process. And the county can even require more enhanced standards, more than the minimum, with these areas that has the potential of flooding. So these things, if it proceeds, they definitely will be evaluated during that site plan review process, thoroughly and completely.
So, quick question, Caleb, before we get into more public here. We're talking about this pond. This pond, was it dedicated from that subdivision development to Escambia County? The
Yes.
one that Yellow Rose Drive is? So
It
it's
is a
part of that?
public pond.
But is it for that specific subdivision? Because I'm not seeing how, at least I'm not seeing from these pictures and from Google Street View. how
On the
it's doing.
plat, which consists of Rosewood, Yellow Rose, and those subject roads, that pond was dedicated as a public pond within that plat.
Okay, because what I'm seeing is I'm just doing a quick Google, search, or not search, but, Street View, and I'm seeing how public right-of-way is draining into this pond. So,
There may have been a redesign at
I mean,
a
I'm just
later
looking
date,
for the
yeah.
pictures that they supplied, looking from this. So I'm just trying to understand a little better how that subdivision is working with that pond. I mean, that's kind of my question here on that one.
Absolutely.
So,
So to clarify, it is a wet pond.
Dedicated on the plat, done way back when, it was a public retention pond. Now, again, to attest to the residents of there may have been a redesign or something at a later date, but it was dedicated as a public retention pond.
And there were a different set of standards.
Correct.
We want to be clear. There was a different set of standards that were utilized back then. Again, the county has higher and more enhanced standards now that they will be evaluated at doing and at that process.
What was the date of the dedication?
February 1995. Yeah.
All right, our next speaker is Kadaji Hurst. If you please come forward, state your name and address for the record, be sworn in, and we'll start your time.
My name is Khadijah Hurst. I live on 6016 Yellow Rose Drive, Pensacola, Florida, 32526.
Okay, raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I would like to kind of piggyback off my neighbor's testimony. I live 2 doors to his right. Specifically, we have had drainage problems that look exactly like that picture in off hurricane season. In January, the 2nd of January 2017, and I apologize, I don't have photos, but if I'm telling the truth, I have those photos where I could present from January 2nd, 2017 and December 1st, 2018, which, as we know, is outside of the hurricane season as it ends November 30th. So it's not just post-hurricane that we get that much drainage, that much rain. And actually, if you were to go down Mobile Highway, just if you were to turn from Mobile Highway to Bellevue, you would start to see the drainage in the retentions on the side of the road. As I approach my house, I already know that I may not be able to enter my neighborhood if I'm driving in my Chevy 2-door sedan because the water is just too high. I've literally had to park at a neighbor in Zachary Estates' house just to walk to my house because the flood is not going to do anything but total my vehicle. So that is one of my main concerns, is this a premature plan? Because I did actually see the plans to create drainage that flows down. Should we at least see if that will improve our situation? I saw that they were trying to make ditches larger. I just have concerns there. And then as far as the 2-lane highway, 80 more people. I don't know if this is the right committee, but that just seems like a lot more visitors down the road where we already have people flying through, and the 2 to 3 speed bumps is supposed to be our problem solution to that, and it just doesn't seem like it quite is enough. As far as community growth, we do have 3-story townhouses just around the corner at the edge of Bellevue and Mobile Highway that are being built along with construction on the other side of the road, where I just wonder if this is going to be problematic for us as far as creating more congestion in our area. And then do we have the schools? I know we said at the time that schools were not at capacity, but we haven't included all this new construction. Would that still accommodate that without causing concerns? Thank you.
Thank you. All right, our next speaker, I've got Edward and Jacqueline Linning. If you'd both like to speak, if I could just get a form from both of you, or if it's just one of you. And if you'll just state your name and address for the record and be sworn in.
Jacqueline Lanning, and it's 5001 Bellevue Avenue. Pensacola, Florida, 32526.
Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. As you can tell, we're right there at the south, the little blue house. We look directly at this property. We've looked at it for the last however many years. As the previous neighbor had said about the congestion going on, both between Bellevue and Softly, on both sides of us, on Mobile and, what is the other highway right there? They've got new townhouses, apartments. They're building some over near the elementary school. And those are main highways, you know, they've got a little bit more room. They don't have homes right across the street. You know, it's a quiet community. We've got near, 7/10 of an acre with our property and currently trying to sell it. My mom was living there and we moved her. So it's one that we're working on. Okay, right now, as y'all were saying with the zoning, it's already 4 homes per acre, which should be adequate for a subdivision as such. If you look at the neighboring subdivisions along with their water, why do you need 10 homes per acre up to? That's like 200 homes in a 20-acre spot, and then that's not even allowing. Bellevue Avenue we have a sewer there, the sewer line we pay. Will that not make the sewer harder worked or need improving on? I think we're one of the only homes that are on the sewer, perhaps at that area of the private homes. We've spoke with other neighbors that are also, you know, disappointed because we're concerned, like y'all had said, no apartments, and it'd be single-family homes. Okay, how is our property value gonna go when you've got that many single-family homes? Are they gonna be 1,000-square-foot homes, 1,500-square-foot homes? Will there be any minimum? Will they be 2-story, single-story? Like how? You know, we don't see the necessity of the difference in the zoning if, you know, right now it's allowable to put an adequate subdivision if that's where y'all are really going. Why increase it to that many? You know, we just don't, all the extra, like the other neighbor had said with the traffic, people already go through there, there's speed bumps. Sometimes you see people come flying over the speed bumps and do aerial Dukes of Hazzard things. But, you know, if we've got that many more people, and then too, the construction, okay, we're trying to sell. How is that construction? How long will that take for the construction to complete itself before we have to sit on our property to sell it? Because nobody wants to buy a home when you're sitting there looking at 20 acres of construction per se. And I know I'm short on time, but I know a lot of the neighbors might not be here, but they're very disappointed because it's a quiet neighborhood where you walk your dogs and your kids up and down the road, where you don't get that a lot, like further over toward Michigan and stuff like that.
How's it gonna affect the value of our house?
Yeah, we're concerned with our value of our home also, to, you know, because we moved my mama closer and, anyway.
Thank you very much. All right, our next speaker is Don Tinker. If you'll please come forward, state your name and address for the record and be sworn in.
Don Tinker, 6050 Yellow Rose Drive, here in Pensacola, 32526.
Okay. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. Good morning. I'm not too accustomed to public speaking, but anyhow, you know, this zoning was made on, and decision was laid out when the House of Prayer of All Nations acquired this property. They knew what they were acquiring and things, and they came out, they looked at the property and said, hey, this is a great place where we can build our church and flourish. And I actually have a card from one of the gentlemen that attends that church. He gave me that day as they approached and looked at the property. They said, yeah, we envision soccer fields and things like that, and it would be good for your community. And so far, it's sat vacant. I've been at that residence for 27 years, and I've seen a lot of things that happen, and I can attest to all the flooding issues and things. One of my neighbors who can't be here because she's leading a homeschool classroom lives in my neighborhood, Rosewood, and butts up against Zachary Estates. Well, unfortunately, it doesn't take much of a rain to create a flooding problem in her backyard. And because there's no easement there, just as David had said, it's left to the individual property owners to deal with it. Now, also within Rosewood, all the other neighbors have the same problem. Clay bed right underneath their little sod grass, standing water, and if you go and drive in our Rosewood subdivision, you can see the dirt staining all along the curbside everywhere you go in there. It exists, and then we're not opposed to development by no means, but certainly density compounds problems and issues that are not seen. And decisions that were made previous to you members of the board and things, I don't see a need and do not understand, no matter how much you explain with aerial photographs, single snapshot photos of that property on how it's going to be different. It would be one thing if someone walked out there with us, grabbed some neighbors and said, hey, show me, demonstrate to me, or let me understand what your existing problems are. And as far as burglaries, we were at one time the highest area per capita of burglaries. And I lead our neighborhood watch program and brought it a long ways just to alleviate that. That property, like I said, I'm not opposed to it being developed, but the density is an issue. And I'd certainly appreciate some real, on-the-ground look at the problems, issues, and concerns of all of us that live in that area. I did have one more thing, if I could.
Just make it quick. Yes, sir.
All right. The Bellevue Elementary and Bellevue Middle School share a parking lot. Morning drop-off and afternoon pickup is always a traffic issue when it comes to Bellevue Avenue and Mobile Highway. And like David said as well, heavy vehicle traffic is being routed off of Blue Angel to come down Bellevue to hit Mobile Highway and avoid Softly Field.
Thank you very much.
Thank you.
Our next speaker is Larry Fetterman. If you'll please come forward, state your name and address for the record and be sworn in.
Larry Fetterman, 4971 Bellevue Avenue.
Okay, raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Okay. Big issue, we just bought this home a couple of years ago. We've lived there. And water issue is a big problem. Sewer system isn't large enough. When we get you get a rain of 2 inches, you can't flush your toilet. You can't handle the water through there. You're going to put in all brand new sewer system, bigger? I couldn't believe it. And I had to go ask neighbors, what's going on? I can't even flush my toilet because it rained. And then in the mornings, I found out from one person I talked to, he said, well, one issue we have, he said, ever you notice you don't have any water pressure in the morning at the sink? And I said, yeah. I said, I thought it was something wrong. And with the plumbing and stuff, started checking into that. Now, and the well out there apparently, from what I'm told from other neighbors, isn't large enough. So the water pressure's down in the morning, but then in the middle of the day when everybody's gone, showers are done, they're out, the water pressure comes back up. And now you're going to add all this across the street from my house, and they can't handle it. You're going to dig up all the sewers and cost all that more money to replace all that so we can, have water pressure and stuff and flush our toilet when it rains? You guys don't care. Nope. And, you don't check with people. And it's ridiculous. And I bought that because it looked like a very nice neighborhood. It is nice. Traffic is terrible. You add that much more traffic on there, I get accidents right on the corner of Muldoon and Bellevue where I live. Every day, almost. People just run that stop sign. They don't care. All these kids, school buses and stuff come down through there. You just add so much more traffic. And You know, I just don't see where it's necessary. Not that kind of housing to put in there. So that's what I've got to say about it.
Thank you very much. Our next speaker is Mary Konopka. Probably butchered that, I apologize. If you please come forward, state your name and address for the record and be sworn in.
My name's Mary Konopka. I live at 6248 Muldoon Road, Pensacola, 32526. I do. Before you start my 3 minutes, I've got handouts because 3 minutes will not cover everything I have to say. So I put it in writing. You want to accept it or not?
Board, would you like to take the written testimony? We'll take a look at it. Staff, if we can.
While we're reviewing this, could you please pull up criteria E again?
Attorney, I got a question. I always want to protect the record with these proceedings. Attorney, she has presented written evidence, her written testimony. Now, to make sure to preserve the record, if the board so desire to take this in as evidence, I'm just trying to make sure she's clear, understand, so we can always be clear, that if she does not verbalize her statements here at the BCC meeting, can she say what she did not say at the BCC meeting because it has been submitted as evidence? Because we got transcripts that are being taken. I'm always on the account of preserving the record for these matters. Sometimes if they go to court, that it won't be thrown out. So, yeah, no, I just want to be clear for y'all, just to make sure that she's clear to preserve her record as well. So,
Yes, we want the commissioners to see the evidence.
Okay, 1 second.
I'd say it all, but I only have 3 minutes. So, well, what are you supposed to do? So I wrote it all down.
I just want to make sure that the attorney, to be clear.
It's the board's discretion whether to accept or reject the written
If
communications.
you want me to sign it, I'll sign it.
So once it's the board's discretion to accept it, if it becomes part of the evidentiary record, I would say that it could be presented at the BCC meeting because it's part of the evidentiary record. However, I would caution the board to accept written communications. Typically, it would be a summarization of the points made in that the testimony would be provided, rather than accepting straight written communications.
For opinion testimony, that is okay, though?
Is this the testimony you'd like to give and speak to, whether or not you got the time or not? If you had a half an hour, is this what you would like to say?
That's part of it. I'd like
that
to
you-
address what was addressed today, too.
So here's my thought. Point 1, which is the drainage, is definitely what everybody else has been talking about. The traffic, the schools, the security, and the parks and open spaces are not our preview. So in my opinion, I would say read what you have to say on the drainage. We don't have to take the written thing, because the only thing that matters is actually what the Board of County Commissioners remanded back to us was the drainage. The rest of it is not in our preview to discuss.
Okay.
So that's what my opinion is.
No, sir. That's traffic, actually.
That usually gets taken care of after we're not allowed to really consider that in today's hearing, unfortunately.
Can we pull the criterion up on the screen for everyone too?
So the board, Reed has made a suggestion that if we have Ms. Knopp go through the drainage issues, which has been remanded back to the planning board from the county commission, that would be maybe the best use of time here, and then adding on any other evidence you'd like to give as well. I don't think we have to make a motion if we're not going to accept it. Board,
I'd just like to offer up that criteria E does, if you look at the last statement there, will a rezoning contribute to sprawl? And I think sprawl is a product of traffic. It's a product of what happens to our schools at max build out. Once again, it'd be nice to see the numbers, the impact on our schools of max build out with the new zoning. And I get it, traffic has put their assessment in here. But again, criteria E, will this contribute to sprawl with a rezoning? So I think these other, even though the county commissioners specifically address drainage, I think it's within our purview to look at the other issues as well that concern the citizens, i.e. traffic, impact on our schools.
all right, board needs some direction here, or we're gonna move on.
I recommend, if this is her statement in writing, that she has the 3 minutes to get through what you can get through.
Like that idea. I think just conceptualize it the same thing you would with the Board of County Commissioners, because I'll tell you that when this goes up there, you're gonna have your 3 minutes to talk too. Same thing here. I
And
mean,
remember, you have the ability to communicate with your county commissioners at any time. It doesn't have to just be at the county commission meeting. So you could email this to them, you can have a conversation with them. Doesn't have to be, submitted into the record for anything other than just.
Sir,
Sir.
please.
Yeah.
Ma'am, if you're okay with it, read through this. If you're getting close to time and you haven't gotten quite all the way through it, I'm gonna let you keep going, okay?
Okay, but he brought up a good thing. If you send all this to the county commissioner, is that ex parte?
No, ma'am.
Okay.
No, ma'am.
Okay, is that good with you? All right, let's
On your mark?
go. You got it, you're good.
Chris, I want to be,
Stop.
hold on for a minute. I want to be clear, because I think Mr. Reed asked a good question. During the rezoning processes, do they have the right, during the rezoning, to send information to the commissioner after the planning board? Is that in sync with the quasi-judicial rules? I want to be clear, because we gotta preserve the record and gotta make sure we follow by the same.
And I hear what you're saying, Horace, but to me, this has nothing to do with actually the parcel that is going to be rezoned. This is their community that they're having issues with. And they've had issues with this community for a long time, for drainage and sewage and traffic. Has nothing to do per se with what the zoning is. This is just a place for them to voice their concerns. But this is something I think they've been dealing with the county for a long time. And if, I feel that.
We don't want to change the density.
Sir,
Enough. The ability for y'all to communicate to your staff, your county commissioners and stuff on issues like this that have been going on for years, I think y'all should be doing that on a regular basis, knocking on the doors as much as you possibly can. So that's my opinion of what y'all, next steps is, has nothing to do with this zoning. And if you keep it out of the zoning,
That's the key.
you have the ability to talk to them as much as you want to. But if you start bringing into the zoning, now we get into rules and laws and stuff of that nature that you cannot talk about unless you're in a quasi-judicial meeting, such as this and the Board of County Commissioners. So if that makes sense, y'all read between the lines what y'all need to do. Communicate with your county commissioners. Don't talk about the zoning.
I'd like to clarify a point. I'd advise the board and the public for that matter to review resolution number R96-13, which governs ex parte communications over pending matters. That defines ex parte communication, and I'll go ahead and read it verbatim. For the purpose of this resolution, an ex parte communication means an oral or written communication or presentation of fact or evidence to one or more quasi-judicial decision makers made outside of the public hearing by a party, witness, or advocate. So that would be information related to the zoning matter coming before the board would qualify as ex parte communication. The public can always contact their commissioners. Any ex parte communication received by quasi-judicial decision makers would have to be disclosed, and it's presumed non-prejudicial if it's disclosed there. So it does not bar citizens' rights to contact quasi-judicial decision makers. They always have that right to do so, but that information would have to be disclosed if it is received and viewed by the quasi-judicial decision maker.
Okay, so here's what I'm going to give advice to everybody here, and then we're going to let you speak, okay? You've been up here for a minute. If you want to talk to your county commissioner about this, go ahead. It's up to them to make a decision on if they're going to disclose if it was prejudicial or not, and that's not on you, that's not on us. That's on them to make that decision. So if you got an issue with something, let it be known, reach out, contact them, and at that point, it's on them, okay? All right, if you go ahead, and we'll let you give your testimony.
Go. All right, so one of the things I wanted to bring up real quick, parks and open spaces, that's a Florida state grant thing. I can't apply for it, but anybody in a county position that does this stuff can. And I'm angry at the church because they lied. It's like, oh, we're gonna have a church and all these open spaces and parks and tennis courts and soccer fields, and that's not. They want money. That's what it's all about. I want parks and open spaces. Drainage, no, I don't live within 500 feet of that property. I probably live 501 feet from it down Muldoon Road, but I get all the wash down Muldoon Road. I have a business on Muldoon Road. I keep the drive dirt. I don't want asphalt on that drive. It makes it really hot. We repair lawnmowers. I have people who try to drive their lawnmowers off their truck and fall over. It's easier landing on dirt than asphalt. And from the north, here comes the water, and it washes away my dirt. And I've had the drainage pipes the county put in exposed because all the dirt washed away. The back of my property, which is right near Hogan's Pit, floods every time it rains. It doesn't take pre-hurricane. You might think it does from listening to these other people, but it doesn't. It's really all hard rain. My back property floods right near Hogan Pit, but you know what? Hogan Pit's up there, my property's here. So where does the water go? Not in the pit, it goes to my backyard. So I don't have any access to my back. Everything's up front. So the drainage is really horrific. And I Traffic's horrific. I don't have much more to say except what's on there. Parks and open spaces. I like my hoot owls. I like my squirrels, my little rabbits, my baby bunnies that are wild. I think that supposing and guessing that this building won't affect drainage. That's why Burgash sent this back here, because he's walked that area. He's been there after it's rained. He knows the area, and he's really concerned. And although in the meeting here initially, Mr. Jones says, oh, sometimes developments help drainage. In the Board of County Commissioners meeting, they asked an engineer, and the engineer said, we can't guarantee that it's not going to flood even worse when you build that much, when you put that much concrete jungle. And already you know there's a drainage pond not sufficient. I just think that we need our park and open space. Thank you.
Thank you very much.
Thank you.
All right, Andrew Brewer, if you'll please come forward, state your name and address for the record and be sworn in.
Andrew Brewer, 6101 Midas Place, Pensacola, Florida.
Raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I also want to be sworn in as a subject matter expert of how dumb county engineer is. And y'all look like 6 intelligent people or whatever, and I know it got remanded back to y'all. So if you can do right now, certify me as a subject matter expert.
And what exactly, sir?
The intelligence of engineering and the flooding in Bellevue Avenue, Hogan's Pit, Zachary Estates, Rosewood Estates, Tanglewood Estates, Amber Ridge. He says that they're all 100-year ponds now. But how come Amber Ridge? How come Tanglewood? How come Buckland Drive? Those 100-year ponds ain't working. How come we spent millions and millions of dollars on 3 projects on Godwin Lane? So I'm a subject matter expert. I want to be certified.
Okay.
I'm 10 times better than any engineer.
We
that
can't
the
do
county
that,
has.
and we don't want to waste your time. Your clock is ticking. We don't want to waste the time with this. Please
Okay.
continue your statement.
Well, y'all waited to signing pictures and stuff. I want to be certified as a subject matter expert.
I didn't have a motion to do that, so this time we'll continue
Well,
with your
y'all look
statement.
like 6 intelligent people. What, you don't like my Trump hat? What's wrong with y'all? Okay, well, here's this thing. This guy from Baton Rouge, Louisiana, if he wants to have 200 houses in 20 acres, he can do that in Baton Rouge, Louisiana. As a matter of fact, I mean, why don't he make a berm all the way around his house or whatever and put the 200 units in his house, in his front yard or his backyard? He doesn't have to come here. How much money does the county spend just with Rosewood? How much money did we spend on that, fixing that holding pond? How much money did we spend on fixing Zachary Estates 4 holding ponds? How much money did we spend? How much money we did Barefoot Estates? How much money we spend on fixing that holding pond? How about Tanglewood? We had 3 stormwater projects on Godwin Lane for Tanglewood. We had another project for Amber Ridge. We had another project on Godwin Lane for the other thing. And we still I got pictures right here. You want pictures of the holding pond there on Buckland Drive or water? It's still full. County engineering is supposed to have been fixing that. I took it today. The pond's full. I've got a work order to, road department to fix it or whatever. Where's our county engineer representative? Do we have one? Oh my God. You're the county engineer representative.
All right,
I
Mr.
don't
Brewer.
think so.
Address up here, please.
We don't even have a county engineer representative.
All right.
So we got flooding. We've got flooding from Godwin Lane coming all the way down onto Bellevue Avenue. We've
Thank you,
got
Mr.
flooding
Brewer.
from Zachary Estates
That's your
that comes
time.
down
Thank
Bellevue
you.
Avenue.
Thank you.
ECUA,
Thank you.
the ECUA storm,
Sir, thank
Time
you
is
for your
up.
the
time.
manhole covers get blown off.
Jacqueline Rogers, if you please come forward, state your name and address for the record and be sworn in.
Good morning, gentlemen. My name is Jacqueline Rogers. My address is 1420 Ridgeway, Cantonment.
Okay, do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. I wasn't going to speak on this, but I just want to say that you guys are giving out this criteria in the beginning that we have to speak to. You are again leaving out the bottom part of section 2-7.2 LDC zoning map and text amendments. This is a zoning map amendment. It's changing, it's a rezoning. It says here clearly, and this is why Mr. Rushing, I believe, is incorrect when he says you guys cannot consider this other information. It says board action, this is number 5. So you have all those criteria, and then there's something about mobile homes, which why they stuck that in there at that point, I'm not sure. Then it says board action. If the reviewing board, and this is you, and I'll show you this is you, finds from the record of the hearing that the applicant has presented competent substantial evidence establishing the required conditions, that is, the applicant has met all the criteria, the board shall then consider, you have a job after that, whether maintaining the current zoning, which in their case is LDR, will serve a greater public interest. Then it says the board shall recommend approval of the rezoning request to the BCC. So they are talking about you, the planning board, because you're recommending it to the BCC. If the board, again, the planning board, finds that no new uses or density or intensity of use of the proposed zoning will likely diminish quality of life. Those are quality of life issues that she was talking about. Reduce property values, yes, you have to have proof for that. Confer special benefit on the subject property to the detriment of the community as a whole, or create other adverse impacts. That's flooding. Flooding is an adverse impact that you must consider, even if the applicant meets all the other criteria. You and the board must consider this. You cannot pass this responsibility off to the BCC. It's talking about you. It's saying, if you're going to recommend approval to the BCC, to the detriment of the community as a whole, or create other adverse impacts upon surrounding properties more than the uses, density, or intensity of the current zoning. So if upzoning it to MDR is going to make more adverse impacts, you guys aren't supposed to be approving it. You're the planning board, and while you're not responsible for the infrastructure, you can demand from this staff more competent and substantial evidence that this recurrent flooding is addressed. There's very boilerplate. Every time I come to these meetings, they're boilerplate, and I know you've been asking for more, Mr. Ingwell, more documentation. That's what you all should be requiring. That you must consider these things even after they meet all the criteria. Thank you.
All right, next speaker is Mark Coonrod. If you please come forward, state your name and address for the record and be sworn in.
Hey, good morning. My name is Mark Coonrod, 1500 Vert Lane, Cantonment, Florida, 32533.
Raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. It seems to me like the board recognizes that there are problems in this general vicinity, you know, whatever it is, if it's traffic or flooding or a combination of things. And referring back to the approval conditions, the item E says that you have to determine that it is in the public interest to allow the new density. I'm going to cut a few words out of there, but that's you know what it says in item E, which may be why it was remanded back to you. kind of as Jacqueline was talking about a minute ago, that, you know, you all have to consider whether this requested change makes good sense, whether it serves the public interest or is contrary to the public. And if it doesn't serve the public interest, then you don't approve it, is how I take it. I don't see, with the problems that exist right now, that have existed apparently for many years and still haven't been addressed, I don't understand what logic would approve taking an empty field that is zoned to allow 4 units per acre and say, oh, you can have 10 units per acre. That doesn't seem to be in the public interest. Seems like it would be public interest to get some of these issues addressed probably before anything goes on, but in that field. But you lay the groundwork for unease and discontent in the entire neighborhood when you grant additional rights to folks when the rights of the people who live there are being trampled on as it is. And so, anyway, I yield the rest of my time. Thank you.
Thank you. Chris Kerb, if you'll please come forward, state your name and address for the record and be sworn in.
Maybe you can give us the date of the expansion of Hogan's Pit.
Still in design. Chris Kerb, 5999 Somerset Drive, Pensacola, Florida, 32526. Truth and nothing but the truth. That's what I spit. All right. I'd like to be sworn in as an expert witness. I worked 25 years in Escambia County. I know the stormwater area. I know the basin studies. I know what the county's doing on the stormwater out here. I know the new code's coming in. So I'd like to be sworn in as expert witness testimony.
I think with his history that we can allow that.
Chris, further credentials, the degree?
I have a civil engineering degree from Auburn University. I worked 25 years in the stormwater, in the engineering department. First 11, I did development review, pretty much stormwater and subdivision regulations. Worked 7 years doing capital improvements. And the last 7 years before I lost my job here, I was a stormwater engineering manager. Actually prepared a lot of the budgets that will eventually address the flooding in this area, but that just requires money.
While previously working for the county, did you ever testify as an expert witness?
Many times I've been to court on different things, code enforcement on different things. I actually was in a federal case as an expert witness for Bristol Park subdivision, a class action lawsuit where the neighbors in there flooded and they sued International Paper.
I'd like to make a motion to accept him as a expert witness.
Second.
Any discussion?
You still, is your engineering license still active?
I do not have a professional engineering license, and one reason and one reason only, well, there's actually a couple of reasons, but I never will have a politician tell me to design and seal something that I'm not comfortable with, which that's happened in this building before. The other fact is I never did pass the test, so.
Any further questions?
I would advise that the board consider him an expert. You would decide on what exactly he's an expert in the motion.
Stormwater.
Find my motion then to accept him as an expert witness based on his experience with stormwater management and engineering.
All right, does the second still stand? All right, any further discussion? All those in favor, please signify by raising your right hand. All right, motion carries. Chris, please go ahead.
Thank you. I really didn't prepare for this. Thanks, Andrew, for giving me a call this morning. But so I'll do it on the cuff. I'm good at doing that. August 28th, the Professional Advisory Committee had a meeting to discuss rainfall data used in stormwater designs, something I've been harping on for the last 3.5 years. In January, y'all will be probably hearing that testimony or that code change in the design standard manual. I don't have a schedule yet, but I think that's planned that way. There was testimony in here, I guess, from Horace that, you know, we're using a 100-year design storm. Are we? I submit to you that we're not. We're using 1979 rainfall data. And the difference is 2.76 inches if you're at the Pensacola Airport rainfall gauge, and 2 inches if at J rainfall gauge up there. Well, you multiply that over a big, large area, and you get a lot of water that's not accommodated. David Fitzpatrick here, he said this was one of his. I asked him, was he going to use? Excuse me?
We never did get his.
Well, he has a professional engineering license. So I asked him, was he going to use No Atlas 14 for his stormwater design? He says probably, but he's not required to because the code hadn't been changed yet. That's a big problem. Section 2-7.2 in the LDC, just as Jacqueline said earlier, public interest. There is a lot of flooding in this area. I can attest to it. I've been out there. The county's even got a project that they're working on. Actually met with the county engineer just a little bit. I can't remember the actual date, but we were going over, it's called the Velma Softly Field Muldoon project. It's actually on their website. It's quite expensive stormwater system that's been, I think they've been looking at this study for, I don't know, 5 years now, 4 years. They were looking at it before I left the county. And the number one project that they're going to try to go after will be a DEP resilience grant. And they're going to be expanding the Hogan Pit and putting drainage on Bellevue Avenue. The problem is it doesn't exist now. The capacity of the drainage system on Bellevue Avenue is under capacity, as attested by these folks saying it floods all the time in that area. And you are a planning board that's not responsible for the infrastructure, but I'm telling you, the capacity is not there for stormwater at this time. It will be in the future. Thank you.
Thanks, Chris. So, all right. That was the end of our speakers for this case. Board members, do you have any questions for the applicant, staff, or members of the public?
I have just one question, based off of Chris's testimony. You said he says that the law is going to, the rules are going to change in January for stormwater. And my assumption is this is November-ish. Building out this subdivision will probably be within the new laws. So that would be a benefit for the community, correct? Chris?
It's the date of approval of the preliminary plat or construction plans. Whatever code's in effect at the time is what will apply. All those subdivisions around there, Zachary Estates, I think you mentioned that one for one, Rosewood, they're based off 25-year stormwater designs, not 100-year. They didn't change that criteria until 2015.
But the criteria has now changed, and
the PAC has changed it for 100-year based off of NOAA Atlas 14 rainfall data, which is dated 2012. That doesn't even include April 2014 Hurricane Sally. That won't be coming out until, in 2023, last year, there was a bad flood then. That won't even come out to 2026 to be up to date and current. That's based off Congressional Floods Act and Precip Act. So NOAA's still working on getting our rainfall data to a point where we can use it. But we're still using 1979. I mean, come on, almost 50 years old. So. Any other questions?
I don't have any. Anybody else?
I have a question kind of related to Chris for David. Is that possible? For Fitzpatrick, the engineer?
Yeah.
David, what is this, if you design this, what code are you going by today?
We're required to go by the code that's present today. If we don't design it till next year, then it might be adopted in January. If it is, we'll use Atlas 14.
What are you doing right now, currently?
Right now, we're using the code as today. It's not the Atlas 14.
Is it 2020? I'm trying to remember.
It's the same rainfall data curves that we've had for years and years and years. It's just it's gone to the 100-year storm now versus it was 25-year in 2014.
Gotcha.
Any further questions? Chris?
If I may add something here, the 1979 rainfall data that both Escambia County and Santa Rosa County is using has been archived by DOT. It's marked clearly across there on their website, do not use in design. Yet we're still using it.
Any further questions? And yeah, now I'm going to allow Meredith. Sir, please. Meredith.
Yes, very briefly, just to address some of the citizens' comments. There's been a lot of talk of 200 units. While I understand the board can't, base your rezoning decision on the actual proposed use by the applicant, I would like to point out that the density anticipated on this site, and there is a pre-application that's been filed, would be 4.47 units per acre, so not max build out of 10, it would be 4.47, so slightly over the 4 allowed in LDR. As far as quality of life and flooding issues, all of the testimony you've heard today really relates to flooding problems in the adjacent neighborhood. What you've heard, the expert testimony has been that this will improve those conditions either through joining the stormwater pond or through other avenues that the county is currently funding and designing to rectify some of those flooding issues. So I would just remind the board that you have received competent and substantial evidence both in our submission and in the staff's findings that we've met all 5 criteria. The staff's findings related to criteria E did not change today, that we have met that criteria E. I don't believe anything you've heard from the neighbors changes that or rises to the level of competent and substantial evidence to change that finding, and we would just ask for your approval.
Does anyone have any questions for Meredith?
Once you approve it, you can put the team in.
Any questions for staff from the board? Think how to ask this. Have you seen, or is there a way in which a planning board decision can be made that includes stormwater mitigation that's contingent upon the rezoning?
So the board is tasked by the LDC to consider the criteria in 2-7B4. Those are the criteria that have to be stuck to. There are certain conditions which arguably relate to stormwater, but the decision has to be based on the established criteria.
Say it. Disapproval.
I mean, I understand and I appreciate everyone coming out to speak on this, and I see where. All right. All right, I appreciate everyone coming out and speaking on this one here. But there seems to be a consistent theme, you know. We're talking about every other parcel in a county road, technically around this site, not this actual site. We're talking about the change of use in this, and that's what our board's here to do, is follow this criterion to change of use for this specific property. But everyone has talked about specifically over and over again about existing flooding issues in their own respective subdivisions. And this is where I would imply, this is where that your elected officials and your development services people are the ones to talk to in regards to these issues. We have multiple layers of local government that are here for this. And in this area, I understand, is prone to this. We've been shown that it's prone to this. For this specific site, though, I don't think to say that this is, from a rezoning standpoint alone, not the improvements that would be coming from a development review committee perspective. This site on its own right now is not contributing, that I can say, to this. And I just implore everyone in this area, and I'm looking at every single one of these neighboring developments, and I keep seeing one consistent theme, is Escambia County is the one who maintains the roads and maintains the stormwater infrastructure in the respective subdivisions. I implore you to speak with your elected representatives in regards to this matter. But once again, by the criterion that we're doing on this one here, and I would also implore after the fact to go to the development review committees and voice your concerns for that. But on this one, for the criteria that we have, I think our hands are kind of held tight.
So, excuse me, everyone's gotten a chance to speak. You've given your testimony. So, yeah, she's the applicant of the property. So I'm done. We're done. Okay. So, board members, are there any comments or questions for the applicant or staff still? If not, then we'll continue to move on with accepting a motion for what we'd like to do here.
We'll do it at the county commissioners again.
All right, I'm going to ask one last question. The county commission put this back to us to further, I guess, flesh out stormwater issues in regards to criterion E. And I guess my question is, what's the anticipation on how to take care of that issue for them? Other than, I mean, we sit here and if we're going to vote like we did a couple of months ago, that doesn't really fix anything up from their end of the table that I would assume that they wanted us to look at.
So this board provides a recommendation to the Board of County Commissioners. Importantly, the evidentiary record is added today, so the testimony of the citizens as well as the experts are now part of the record for which the Board of County Commissioners to review and consider that evidence that was presented. But your recommendation is a recommendation to the Board of County Commissioners for the final decision, who will review that evidentiary record.
Make a recommendation of disapproval until they fix the problem.
I make a recommendation to move Z 2024-11 for approval.
Seconded.
Is there any discussion on the motion? All right. If none, then I will entertain all those in favor of the motion, please signify by raising your right hand. All those opposed, the motion carries 4-1 with one person off the dais. All right. We'll move on to our next case. The next rezoning application for consideration is case number Z-2024-20, which requests rezoning of 810 Neal Road from low-density residential district, 4 dwelling units per acre, to commercial district, 25 dwelling units per acre, as requested by Meredith Bush, agent for 29 and Neal Development LLC the owner? 1 second, board, as we let everybody clear out. So, all right, members of the board, have there been any ex parte communication between you, the applicant, or the applicant's agent, attorney, or witnesses, fellow planning board members, or anyone of the general public prior to this hearing? Have you visited the subject property? Please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
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 All right, we'll get one more in here. We're going through ex parte communication on case Z-2024-20.
No to all.
All right, staff was hearing of the, was notice of the hearing sent to all interested parties?
Yes, sir.
And was notice of the hearing posted on the subject property?
Yes, sir.
Great. Meredith, are you okay with us going through the aerials and photographs? All right, staff, if you could, please go through that.
Good morning. Allison Lindsay, Urban Planner Development Services. So this is the location map showing the location on Neal. This is the zoning map showing the current LDR zoning. And this is the future land use showing mixed-use suburban. And this is the existing land use of the property. And this is an aerial view of the subject property and surrounding. And this is the notice of the public hearing sign that was posted on Neal Road. This is looking west along Neal Road. This is looking east along Neal. Looking north onto the subject property. Looking south across Neal Road. And that's the maps and photography.
All right, thank you. Meredith, if you'll please come forward. And then did you receive a copy of the rezoning hearing package and findings of facts for this case?
Yes.
And you understand you've got the burden of providing substantial evidence that this is not in conflict with any portion of the county's land development code?
Yes.
All right, please go ahead.
Thank you. I'll just walk through the criteria. Meredith Bush, 125 East Intendencia, Pensacola 32502. So as to criterion A, consistent with the comprehensive plan, the proposed amendment is consistent with the intent and purpose of the future land use category of mixed-use suburban. Criterion B, consistent with zoning district provisions. The proposed amendment to commercial is consistent with the intent and purpose of the Land Development Code. The commercial district establishes appropriate areas and land use regulations for general commercial activities, especially the retailing of commodities and services. The primary intent of the district is to allow more diverse and intense commercial uses than the neighborhood commercial allowed within mixed-use districts. To maintain compatibility with the surrounding uses, all commercial operations within the commercial district are limited to the confines of buildings and not allowed to produce undesirable effects on surrounding property. To retain adequate area for commercial activities, new and expanded residential development within district is limited. Actually, that's is consistent with the commercial future land use category, which this is MUS, so that doesn't apply. As to criteria C, compatible with surroundings, the proposed amendment is compatible with surrounding existing uses in the area. Within the 1,500-foot radius, the applicant has identified property zoned LDR, LDMU, and HCLI to ensure additional compatibility with existing adjacent uses. If the amendment is approved, further review and evaluation through the Development Review Committee process may be necessary. As to criterion D, appropriate of spot zoning, the amendment request, if granted, would create spot zoning. Despite being a case of spot zoning, the proposed commercial designation demonstrates a strategic and coherent approach to development. The introduction of new commercial zoning in this area would technically create a case of spot zoning, as it would establish a distinct zoning district that differs from the surrounding LDR and HCLI zones. However, this spot zoning is appropriate because it functions as a critical transitional buffer between the HCLI and LDR contrasting land uses. By placing commercial zoning between the LDR and HCLI zones, it helps to mitigate the potential negative impacts of industrial activities on the adjacent residential neighborhoods. The commercial zone provides a gradual shift in land use intensity, reducing conflicts such as noise, traffic, and visual disturbances, while offering nearby residents convenient access to services and amenities. This transition enhances the overall compatibility of the area and promotes a more harmonious development pattern. This zoning adjustment also maximizes the potential for economic growth in the region. And as to criterion E, appropriate with changed or changing conditions, based on the existing uses and intensities and the zoning district allowances, the proposed amendment would not create urban sprawl and would be compatible with existing development. It is in the public interest to allow commercial zoning. The proposed rezoning will contribute to a logical and orderly development pattern. One thing that's not included in those findings, if you go back to the existing zoning map, the parcel is actually being combined, and that we're just waiting on the property appraiser to, if you go to the zoning map, sorry, there you go, with that HCLI parcel, so that will all be one unit. It's just not combined yet in GIS. And I'm happy to take any questions. Staff does recommend approval. We're in agreement with staff's findings.
So if it's combined, it'll be a split property?
It would be a split zoned parcel, correct.
Okay.
We couldn't go to HCLI because the future land use category is MUS.
Can you put up the future land use?
So then how did the other parcel get to be
Yeah.
HCLI?
What's going to happen to the one that is currently HCLI?
So I believe that's part of an opt-out, in which you have allowed the HCLI zoning in MUS because the more intense industrial uses are limited by that MUS category. But there is a provision in the code that that states that HCLI zoning is not preferred in the MUS category. It's just in the industrial, commercial, future land use category. So when we discussed this with staff, whether to go HCLI or commercial, they felt that the lower intensity commercial would be a buffer and transitional zoning district between the two, the neighboring residential.
So, yes, Board, to confirm with the applicant, the rezoning criteria of HCLI dictates that heavy commercial and light industrial zoning may be established by rezoning only within the mixed-use urban, commercial, or industrial future land use. So it wasn't available to rezone to HCLI due to the future mixed-use suburban land use.
But the opt-out pre-existed that.
And help me with the opt-out, because this, I believe this was the Robertson's property, one of the first opt-outs, correct?
Yes, that was, his was the first, but this was not his.
This was not his? Okay. When did this opt out? What was?
21, I believe.
Okay.
21, but we can check for the actual date. Yes, sir, it's 21.
And is there plans to, when you combine this, when they combine them, does that mean that this parcel will also be an opt-out parcel too? Give me some history on like combining and what that means to, this parcel.
So they're not in the sector plan because they were opted out. So when they are combined, you still will have the HCLI and the commercial. And because the mixed-use suburban is the future land use, the mixed-use, the heavy commercial, light industrial, because the mixed-use, it's mixed-use suburban, that does sever, if you will, the use of the heavier industrial uses in the HCLI if it's mixed-use suburban.
Are there any other questions for the applicant at this time? All right.
Okay.
We'll go ahead and turn it over to staff.
Okay. So the rezoning, 800 Neal Road from LDR to commercial. For the criteria A, consistency with the comprehensive plan. The proposed amendment to commercial is consistent with the future land use of mixed-use suburban. The intent is to promote new infill development in already developed areas and to be resourceful with existing transportation networks, utilities, and governmental services. This rezoning request to commercial will accomplish these directives by creating the possibility for retail sales and services that will provide daily necessities to residents within a short walk or drive time. The development plan is supported by the Future Land Use 1.5.1, which was created to encourage redevelopment in underutilized properties and to maximize development densities and intensities. Consistency with the Land Development Code on criteria B. The Escambia County Land Development Code, it offers direction when analyzing compatibility when a new use is introduced. Section 3-1.6 compatibility contains criteria that describe new non-residential uses in relation to existing residential uses. Section 3-1.6b states that such criteria are created to allow for residential and non-residential uses to be located in close proximity to each other. Other items of the compatibility may be required, such as landscaping, buffering, and screening to protect the lower intensity uses from commercial use. The commercial district creates appropriate areas and regulations for general commercial activities, especially the retailing of commodities and services. The 5.0 plus or minus acre property will be combined with the 8.76 plus or minus acre parcel that's on the corner of Neal and Highway 29, satisfying the location criteria. Changing the zoning from LDR to commercial would allow for commercial operations along Highway 29 that would benefit the residents in the area and reduce vehicle trips and congestion within a walkable or short drive distance. Criteria C, compatible with surrounding uses. The proposed amendment would be compatible with the surrounding existing residential uses in the area. After a site visit within the 500-foot area, the majority of the surrounding land uses are LDR and HCLI. The requested commercial zoning district is appropriate for general commercial activities such as retail sales and services, requiring all of the uses to be in the confines of a building. The proposed request to commercial will be a transition between the LDR and the HCLI, resulting in a long-term compatibility with existing residential uses without conflict. Criteria D, appropriate with spot zoning. It would establish spot zoning as there are no other commercially zoned properties in the area. The intersection of Neal Road and Highway 29 is an appropriate location for commercial development to serve the residential neighborhood, allowing cohesiveness between residential and commercial aspects of the area. Criteria E, approved with changed conditions. The land uses or development conditions within the subject area surrounding the property, they are changing. There is a new subdivision, enclave at Bella Terra, located on the adjacent parcel to the north. The subject parcel will be joined with this HCLI property along Highway 29, making it a corner lot. The area along Neal Road has single-family residential lots. The request for commercial and the potential uses allowed by the commercial district would be compatible with the existing surrounding residential development patterns. And that concludes staff's findings.
Board, do we have any questions for staff? All right. At this time, we'll move on to members of the public who'd like to speak. Please note that we base our decisions on the approval conditions and exceptions in Section 2-7.2 of the Land Development Code. And note that only those who are speaking here today will be able to speak at the subsequent Board of County Commissions hearing, and if you got a form filled out, which it looks like you all do based on the crowd. So we will go ahead and start with Sharon Colburn. If you'll please come forward and state your name and address for the record and be sworn in.
I'm Sharon Colburn, 1100 Ridgeway, 32533.
Okay, raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but
I do. All right, well, first of all, whenever she's giving all those things, she's talking about how great it is for the residents. I'm one of those residents, and I do not feel that way. In fact, I'd love for you to put the view of Neal Road up there, because whenever I bought right there, when you turn off of Highway 29, you get a beautiful country road. Lots of green, overhanging trees, lots of shade. It is a dead-end road. My neighborhood is at the end of it. This is nothing commercial about this road or this property. When I was looking over the findings, I was looking at the things that it said, proximity to a traffic generator. There's no traffic generator. There's no businesses on the west side of Highway 29 from the paper mill north. There's nothing. It talks about infill development. It says that it needs to be in an area where already established non-residential uses. It's all single-family homes. There's nothing commercial, nothing that's non-residential about this area. It also talks about not abutting to a single-family residential zoning district. There's a neighborhood. It's going to butt right next to neighborhoods. It's right across the street from housing. It says it should benefit residents. We didn't move out to the country to walk to businesses. An outing for us is to get dressed up and go to Waffle House across from Tate High School. If we want to buy groceries, we have the Grocery Advantage. We have a Winn-Dixie. In fact, Winn-Dixie had to move further south to get the business that they wanted. Right now, the old Winn-Dixie is a gym. Businesses at the corner of Muskogee Road and Highway 29, they don't make it. Right now, every day when I drive north, I see a pot leaf wave at me because no other business could make it there. Whenever you're thinking about these, I think that you need to think about perspective. What some person might want. They might want to live in walking distance. They might want to have a grocery store that's close by, but you don't move north of Kingsfield Road if you want those things. We don't want those things where we live. We don't want to live near commercial properties. This is a rural area. We have the grocery stores. We have the things that we need. I was thinking that if I want to buy something, if I want to get like a trailer to haul cows or something like that, I'm going to go to Robertsdale. I'm going to go. We don't have that mindset that you're thinking. We don't want those things close by. And then I'm saying that I don't think that the criteria were met. And if you disagree with me, I think you need to go back and you need to look at number 5, board action. The board shall then consider will maintaining the current zoning will serve a greater public interest. We're not just asking to go from 4 dwellings per acre. You're asking for 25 units of commercial, and that's a lot. Thank you.
Thank you. Next speaker is Mark Coonrod. If you'll please come forward and state your name and address for the record.
Hey, good morning again. My name is Mark Coonrod, 1500 Vert Lane, Cantonment, Florida, 32533.
He's already been sworn.
Go ahead.
Okay. Just several kind of random comments about this rezoning. One of the things is that one of the key topics is that it'll provide a buffer. Well, actually, the current zoning is the buffer. What the applicant is asking for is to upzone an area at 5 acres to provide a buffer to others. Well, it already exists as whatever, single-family home, whatever the existing zoning is. They're not talking about downzoning the light industrial stuff along 29 to be commercial. They want to keep that, but have a split parcel split zoning parcel. I don't know how that would ever end up working out. We have a commercial parking lot, but an industrial facility. I'm not sure how that would work out. I don't understand how, taking another property, upzoning that, and saying, oh well, that's the buffer. It may look like a buffer on paper, but in reality, it's not a buffer. It's eliminating buffer. What's there now buffers everything else that's around it. You change what you can do on that piece, you've changed what buffer characteristics already exists. There's mention about making the change would provide for infill. This, as the previous testimony said, this is pretty isolated location. It's not infilling, this is a vacant lot that, hey, this would be a great site for blah. It's not infilling anything. As far as spot zoning, it says that the impact should be minor or sufficiently limited. Well, going from single-family residence to commercial use, I don't see that as minor or sufficiently limited. That's fairly large impact. Just one thing that's been a concern for many years is that the zoning classifications in the county, and this goes probably back before all of your time, most of the county was upzoned. If you look at the photographs, you look at the current land uses, it's not 4 units per acre. The zoning that's applied to it, retrofitted to it, is 4 units per acre, but that's not what exists on the ground. So I'd ask you to keep that in mind, and maybe the county needs to come up with a more realistic, maybe rural density residential of 1 unit per acre, or one unit per 2 acres, something like that. Thank you very much.
Thank you. All right, next we've got Michelle Cerrone. If you'll please come forward, state your name and address for the record and be sworn in.
My name is Michelle Cerrone, 1380 Ridgeway, Cantonment, Florida.
Okay, raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I moved to this area over 20 years ago, and it's where we raised our children, and we have a barn, 2.5 acres, and had chickens. This is just, going home is something that is just relaxing. And I oppose the rezoning from LDR to commercial. It's an extreme change. It's not compatible with the surroundings. We have houses closer to Highway 29 that are on bigger property lots than 4 per acre, like the gentleman mentioned. And this is an area that we go on walks, and it's not something like the lady mentioned earlier. We didn't move to this area to go shopping. We went to this area to be our haven, our place that we can relax. And it's just been a wonderful place to live. And I believe that this rezoning will be having adverse effects on our neighborhood. Like I mentioned, maybe it is a nice area for walks. We even have wild peacocks at the end of the road. It's pretty amazing, just having that. How would that happen with a commercial? How would they like wild peacocks in their parking lot? That's not something that is something that would be good. And I just really oppose this. And thank you for your time.
Thank you. Jacqueline Rogers, if you'll please come forward, state your name and address for the record, and I think we've gotten you sworn in already, so you're good to go.
I won't lie again. My name is, I don't have to swear, Jacqueline Rogers, 1420 Ridgeway, Cantonment. And if I could have you guys switch to the one before that, I think this one right there, okay. So if you take a look at that real quick, you can see these are the single-family homes. They're generally a large lot. There is a church there also. The first one on the end, and I won't go into the history of the sector plan. Meredith advocated it as the county attorney for the planning board or for the county, and I opposed these. And absolutely, it could have gone to HCLI because that's what this one did. It went just to HCLI. I had to go to Tallahassee to stop it from being heavy industrial, but that's another story. commercial zoning, the primary intent, this is what she has in her application, the primary intent of this district is to allow more diverse and intense commercial uses. Why would you want intense commercial uses? You're talking about a rezoning from 4 dwelling units to 25 dwelling units? How is that transitional? That's not transitional. Why is she not asking for low-density mixed use? That is a commercial allowance there. This is inappropriate. These poor people here, one of them is fighting cancer, couldn't come today. They live there in country homes, and you're going to put a parking lot, apartments. You cannot know what it is. She can tell you what it is. Today, it is not zoned together, so you have to look at it separately. It is spot zoning. There's no commercial anywhere around there. There will be no buffering because the neighborhood that they mentioned that's going in down there has no buffering. They went right to the property line, tore down all the trees. There will be lighting and visual impact to the people across the street. Those are those adverse impacts that you guys have to consider, even if you think they met the criteria, but I don't think they did. Road infrastructure is bad. You can see from the picture that the first speaker showed, there's no shoulders, there's nothing to upzone to 25 dwelling units per acre. She put on her application on page 17, this is infill development. Does that look like city infill? It says appropriate in urbanized areas where infrastructure is sufficient. Infrastructure is not sufficient. This is not urbanized. We have horses, we have farm animals. I'm going fast. I'm not trying to sound mean. I'm trying to go fast so I hit everything in my 3 minutes. So the staff said this was infill development. This is not an urban area. This is not infill. There will be no buffering. They tell you this. They tell you you can address these concerns at development review, but do you know that initial application is not a public meeting? They do not let you attend the initial application. So you can show up at the final application. That's all they let you show up for. You can request emails and sift through those. This is spot zoning, again. And the changing conditions, she's right, there are changing conditions. You just opted all those properties out and let Bellaterra put a bunch of homes in. So now there's more residential, more reason why you shouldn't allow commercial 25 dwelling units per acre across the street from these people. And this map doesn't show, but there's houses right there too. That's residential. This is not compatible. You should deny it. And then you go back to the thing that I talked about with the other group, and I'm finishing with this statement. This will have adverse impacts, and even if you think they did meet the criteria, which I believe they didn't, you have to consider the adverse impacts. This is not a throughway. The location criteria, the only reason why she's saying they're joining it is because this is not an arterial road. So she's going to say, well, it's frontage to Highway 29, but it's not. It's a dead-end road that goes to a couple of neighborhoods. Thank you.
Thanks, Jacqueline. All right. That's the last of our speakers that we had for this. Board members, do you have any questions for the applicant, staff, or any of the members of the public?
Could staff elaborate on their findings for criteria E? Just give a little bit more detail on how they came to those findings.
So,
I said D, didn't I?
D.
I meant D, I'm sorry.
D, okay.
oh,
Spot zoning.
okay, okay. For the spot zoning? Okay. So, let's see, wait, where am I at? So we did say that it would establish spot zoning because they're asking for commercial and there is no other commercial zone properties in the area. So even though there may be a commercial use in the area, the zoning is not commercial. I mean.
Then it looks like you qualify your statement.
Oh, so basically the intersection of Neal Road and 29, because they did have a application for combination that we really thought was going to be edited on the map by today, but so that the intersection, it is a good, what the county is hoping that all the major intersections you would have all your commercial at intersections where it doesn't intrude into a neighborhood. So when these being combined, it's now a corner lot, which fits the locational criteria that doesn't intrude into a neighborhood or subdivision. But with these two properties, even though one's gonna be commercial, one's gonna be heavy commercial, light industrial, you won't be able to do the heavier industrial. You'll be stuck with the heavy commercial versus the industrial. But it is spot as the definition because it's not adjoining or adjacent to parcels that are already zoned commercial.
And though it has been stated, the packet before us today still represents two lots that have not been joined. Therefore, the lot by the applicant for today is not at the intersection of Neal and 29. And so the criteria being appropriate if spot zoning, we've agreed it does create spot zoning. There's no commercial on any side of it. The question is it appropriate? Your qualifying statement of the intersection of Neal Road and Highway 29 is an appropriate location for commercial development to service the residential. Yes, in spirit, that's true. In letter by the packet we have in front of us, this parcel is not at that intersection.
Well, after I spoke to one of the property appraiser staff, he basically said that he had done all the paperwork and the Rock Tech I think if Rock Tech is still doing our maps, that they do it once a month. So basically the property appraiser has combined the parcel. It just doesn't show on the information that's in our current packet because it was done prior to the finalization by the property appraiser to combine them.
We do to attest for general development process in the county. We run into this a lot. It may be 6 months before the tax record's updated. You know, we consider it, once we sign off on it and process the request, the applicant would then take it down to the property appraiser, have it appropriately filed. If we were to hold up things sometimes, you know, it specifically says, this is a property appraiser process, it specifically says that it shouldn't hold up your building permit process and things such as that. So we do run into this fairly commonly.
So you're saying it has been applied and approved, it's just not on the map?
Yes.
Correct.
Okay, so at this point in time, it is a combined parcel, in all legal senses. Okay, thank you.
If you'd like to, please come, just, you can make it quick.
Well, once you combine them, then it butts up to a neighborhood, smack dab to a residential area.
Thank you. All right, board members, any further questions or clarification you need before action's taken on this rezoning case?
Meredith, do you have anything else?
Thank you, Reed.
No, I would just remind the board that you're looking at the competent and substantial evidence presented by both our submission and county staff. While the testimony of the neighbors, indicates concerns for what might be, it doesn't rise to the level of competent and substantial evidence that there truly would be any adverse impacts. It does create a buffer between the HCLI and the LDR zoning. Commercial is a lower intensity zoning than the HCLI, and it is frontage to Highway 29. We would just ask that you grant the rezoning request or recommend approval.
All right, board members. We have anything else, or I'll now accept a motion one way or the other. Yes.
Jacqueline Rogers. I thought the staff was trying to get away from split zone parcels. So that happened when we redid the land development code and the zoning and combined, and we have a lot of problems with split zone parcels. Now, this would be creating a split zone. If you're gonna go with the thing, oh, it's already approved, where there's no proof in the record, and this is a quasi judicial hearing. So if you are to believe that way, then you are purposely creating a split zone parcel. Only because HCLI would never, never, never get approved. And that's a problem. So please consider that you are creating more problems. You are the planning board, and we're trying to get away from split zone parcels. Thank you.
Thank you.
So the parcel is already split zoned. I mean, it's combined as one parcel. It's just split zoned LDR to HCLI versus commercial to HCLI. And testimony of staff that it's been approved and is a parcel is evidence.
All right. Anyone want to take a stab at it?
Walker, what's the long-term plan? Maybe this is a Meredith question. What is the intent with this property, long-term?
So my understanding from the applicant is that it would be a grocery store to serve that part of town.
I'll just remind the board members that that should not be part of your consideration on how we vote or don't vote on this issue, but
And for what it's worth, the store would front on 29 and the majority of it be on that HCLI parcel, but the rest of the property would need to be commercial to get the square footage.
Can we ask where the access would be to the store if it's a grocery store?
question of the access, I don't know if, I get your point, because I'm probably in, I agree with where the access should be, and shouldn't be for something like this. But again, I just don't want us to go down that road too far, since we've already started getting off on the turning lane with it a little bit, so.
Yeah, this is getting in a weird realm, especially this combination causing a split zoning. And that's already done fully. Let me ask you that, because I know when you go to do that with the property appraiser, they ask for a sign off from the planning representative or someone from that, or this county or city, so.
Staff has signed off on it.
Staff has signed off
Correct.
on the combination.
And just to follow up with the split zone parcels, specific to section 3.1-3 of the Land Development Code, section D, split parcels, the LDC does address it. It specifically says, the adopted zoning districts and future land use categories are parcel-based, but their boundaries are not prohibited from dividing a parcel. For parcels split by these boundaries, including overlay district boundaries, only that portion of a parcel within a district or category is subject to its requirements. Where a zoning district boundary divides a parcel that is 10 acres or less in size and not in a platted residential subdivision, the zoning district of a larger portion may be applied. And the rest of the stuff wouldn't be applicable, but it's not prohibited. It happens in, being on the planning board, some of these older parts of towns, we see that from time to time, but it's not necessarily prohibited.
I get that it's not prohibited, but I thought that Escambia County's kind of doctrine recently
Sure.
was kind of to
Sure.
fix that issue. So
Correct.
that they weren't just hanging out there.
Right.
So that kind of goes counter to what we've been fixing.
Take one last comment here from the
Sorry to
public, and then we'll,
But what that,
I'm gonna
what
cut
that
this
just
off.
pointed out to me was that the zoning of the larger parcel could be applied then to the smaller parcel?
Only in certain situations, I don't believe that would apply for this.
Why would it not apply? What are the situations? That's part of the problem. You start It's a shell game.
Thank you.
Can you reread the 10 acres or less portion of
Yes,
unit? Please,
certainly.
thank you.
Where a zoning district boundary divides a parcel that is 10 acres or less in size and not a part of a platted residential subdivision, the zoning district of the larger portion may be applied to the entire parcel if requested by the parcel owner, consistent with the applicable FLU. And,
So this is gonna be, this is gonna be 13 acres as a combined. So now we're over it.
And it wouldn't apply.
So the split zoning wouldn't just assume the other one. So now we actually would have a split zoning no matter what. Is that a correct statement?
Right, yes, and it further says consistent with the applicable FLU. I think that's what we're running to. You couldn't apply the ACLI to the entirety of, due to the mixed-use suburban future land use designation. So we wouldn't ever be able to arrive there based upon that criteria and the applicable FLU, so, yeah.
Okay.
I'd like to make a motion.
Alrighty.
Regarding Z 2024-20, based on staff's initial findings for criteria D and discounting their qualification, I recommend disapproval.
Do we have a second for the motion?
This is a hard one. I'm on the fence really on this one.
I'm gonna second just for the vote purposes, because I'm gonna see, I'm still in quandary with this one. I don't like it going to commercial, but I understand the need for it. But this does everything that we're not normally doing, which is creating spot zoning, extreme spot zoning. But there's a need for it because of the front parcel that's now combined, so I'm gonna approve, second.
All right, so we got a second for discussion. Is there any discussion?
I'll dovetail, Reed over there. It just feels like we're walking ourselves into a spot zoning situation on the fact when that parcel's separate. With combination, I don't love the fact that we're getting into a split zoning. I know it's allowed, but we've been trying to clean that up for a while here, so.
It's still gonna be a split zoning, because it's already
I
split
know,
zoning,
I get that, but I'm just saying is we still got that scenario kind of painting over there. Not in love with that.
Is there a consideration for HDMU? Would it fill the same results that you're looking for?
I believe the issue with HDMU was the square footage allowed would not have been sufficient. There was discussion of creating a parcel 10 acres or less. I mean, there may be another avenue, that will require other maneuvering to accomplish this. But the simplest and easiest, path of least resistance was the commercial zoning. But I don't believe HDMU would work.
All right. If there's no further discussion, then we'll go ahead and take the vote. The motion was to not approve the rezoning. So all in favor of the motion, please raise your right hand. All opposed? All right, rezoning is fails by 5-1. All right, that is the last case we had today for the rezoning meeting. So we will adjourn that and move on to the regular meeting. The meeting of the Escambia County Planning Board for October 29th, 2024 is hereby called to order with 6 members. We do have a quorum. Did we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
The chair will entertain a motion to waive the reading of the legal advertisement.
So moved.
We have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries 5-0 with Reed off the dais. The planning board meeting minutes for September 10th, 2024 have been provided to the board. I'll entertain a motion to accept the planning board meeting minutes into evidence. Do we have a motion?
So moved.
Do we have a second?
Second.
All those in favor, please signify by raising your right hand. Motion carries 5-0 with Reed off the dais. The planning board hearing package for October 29th, 2024 has previously been provided to the board members. I'll entertain a motion to accept the planning board hearing package and the legal advertisement into evidence. Do we have a motion?
So moved.
Do we have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed, motion carries 5-0 with Reed off the dais. All right. We've only got one public hearing today. It's an opt-out application for consideration, case number OSP-2024-02, which requests removing 100 block Harvest Hill Road from the Midwest Sector Plan and assigning a future land use category from Conservation Neighborhood, Jacks Branch, to MUS Mixed Use Suburban, as requested by Meredith Bush, agent for Chase Porechu, the owner. This is property size 1.79 plus or minus acres, and again, from Conservation Neighborhood to Mixed Use Suburban. I think that's it. So, at this time, do we have photographs of this subject property that we can run through?
So this is the opt-out OSP 2024-02. This is a location showing it on Harvest Hill on Highway 29 in Harvest Hill. This is the zoning map showing the current zoning. And this is the future land use map showing the current conservation neighborhood. And then this is the proposed future land use requesting the mixed use suburban. And this is just a detailed, specific map for the sector plan, showing the property in the sector plan as conservation neighborhood. And this is the Jacks Branch, in the outline, this is the Jacks Branch area. And this is the development program, the acreage map for the 1.79. And this is a flood zone map. And this is an aerial map of the site. This was the public hearing sign that was posted on Harvest Hill in 29. This is looking at the subject property from Harvest Hill. And this is looking east along Harvest Hill. The property is on the right. I was facing Highway 29. And this is looking south from the north entrance of the Harvest Hill and Highway 29. This is looking east along Highway 29 from Harvest Hill across 29. This is looking south along Harvest Hill Road, the backside. And this is a public hearing sign that was also posted at the Harvest Hill on the southern entrance. This is looking north from that Harvest Hill in 29, and then looking east along 29 from the subject property. And this is looking south from the southern entrance of Harvest Hill. Looking at the neighboring property on the south side of Harvest Hill in 29. Looking west down Harvest Hill from 29. And this is looking north along the Harvest Hill Road, or on the backside. This is on Harvest Hill, looking east toward Highway 29. And that's the maps and photography.
Thank you. Meredith, if you'd like to come forward and run us through your side of this.
Yes, thank you very much. Meredith Bush, 125 East Intendencia. So I will go through the sector plan criteria. The subject property is not located in a wellhead protection area. There were no historical resources detected on the subject property. There are no wetlands on the subject property. The property is located within the Jacks Branch drainage basin. The property is located within the flood zone X. The soils indicated on site include Porch sandy loam and Malbus sandy loam. As far as traffic goes, the subject properties are located to the west of US Highway 29. FDOT provides an annual average daily traffic count along this portion of Highway 29 of 25,000 trips. All area roadways have capacity to support the requested change in the future land use category. Sanitary sewer and water. ECUA is the area water provider. Once a project is proposed and application submitted to the county, such proposal shall identify any other providers and determine whether septic service or available sewer connection will be utilized. Any proposed development will receive approval through the site plan review process. ECUA will provide sanitary sewer if applicable. The proposed amendment is not expected to create capacity problems for ECUA. As far as wetland and drainage, any necessary stormwater management will be provided in accordance with the Escambia County and Northwest Florida Management District regulations. The stormwater system will be designed for a 100-year storm event. Again, there are no wetlands on site, and it's flood zone X. Solid waste will be collected by ECUA for disposal in the Escambia County landfill, which has adequate existing and projected capacity. Parks, recreation, and open space. If required, the development review process will address the preservation of open space. The applicant understands that a detailed review is required through the county site plan approval and development review committee processes. School assignments. The current school assignments for this location for the 2024-2025 school year are Jim Allen Elementary, Ransom Middle, and Tate High. Any increase in density may or may not have an impact on the student population projections. Any proposed development will adhere to the site plan review process. Need and benefit. There's an identified land use need particular to the scope and function of the comprehensive plan for which the amendment is clearly warranted. The proposed amendment applies contemporary planning principles, engineering standards, and other professional practices to provide an effective and efficient remedy for the identified land use problem or need. And then as far as applicable comprehensive plan objectives and policies, there are, I believe, 45, which I won't bore you by listing all, but 45 comprehensive plan provisions listed in our submission, which apply to this proposal. Parcel size and aggregate of other opt-outs. The subject property is 1.7947 acres. The property represents 0.02197% of the existing development acreage of 8,168.22 acres described in the sector plan. Total acreage of the Jacks Branch DSAP designated conservation neighborhood is 2,359 acres. Withdrawal of the applicant's 1.7947 acres will result in a 0.076078% decrease in developable acres. As of the time of this application, the total acreage opted out of the sector plan is 442.78 acres. Underlying zoning and compatibility with DSAP. The existing parcels are currently zoned heavy commercial, light industrial. The requested FLU category is MUS. The DSAP land use for the surrounding parcels is conservation neighborhood. Based on the residential guidelines language, the conservation neighborhood land use is designed to allow clustered subdivision of detached housing with a maximum density of 3 dwelling units per net acre. The MUS future land use category will restrict the most intense HCLI development. Any proposed development may be further made compatible through buffering and screening requirements of the DRC process. Consistency of the requested FLU with the underlying zoning. The requested MUS FLU category will be consistent with the underlying zoning uses, densities, and intensities allowed by the HCLI, being use dependent. The prior future land use designation of this parcel was MUS and lost development rights. Prior to the adoption of the Midwest Escambia Sector Plan, the parcel was zoned GBD. The parcel was effectively downzoned by the adoption of the sector plan, and a copy of those GBD district regulations was included in our submission. Staff is in support of the request, and we agree with their findings and analysis.
Any questions for the applicant?
Meredith, I have a quick question. The current owner did not lose any development rights. Is that correct?
Well, they did, so it was previously GBD, so.
The current owner did purchase this property after that took place. Is that correct?
You may be correct. I'm not certain. That's the one I'd have to look at the deed, but you may be, if it's accurate that they, bought it within the sector plan, then yes, but the parcel was
Yeah,
downtown.
in the packet, I believe the deed is dated 2022.
Then yes, you're correct.
Any further questions for the applicant? If not, staff will turn it over to you.
Okay. So this is the application that they are requesting to remove a parcel from the sector plan and the Jacks Branch detailed specific area plan, and it is located on Harvest Hill Road. And the applicant is also requesting that the Board of County Commissioners assign a future land use of mixed-use suburban. And based on the public records of Escambia County, property appraisal, the parcel is currently vacant, and the current underlying zoning is HCLI. The existing land use derived from the adopted DSAP final land use plan identifies it under the conservation neighborhood. For sanitary sewer, the Emerald Coast Utilities has a 12-inch force main located adjacent to the property within the right-of-way of Highway 29. And solid waste, any development request will have to be reviewed and approved through the development review site plan. For potable water in the area is supplied by Emerald Coast Utilities, who verified availability by letter. A conceptual potable water distribution system was developed. It's based on the analysis and is available in figure 4.03 of the DSAP. The stormwater management, the amendment itself for opting out, it will not rely on stormwater requirements or calculations. And based on the original analysis in the DSAP for stormwater in the area of the sector plan, the stormwater system would be developed as a regional system and would encompass multiple areas of development. For the traffic access and streets, the Midwest Sector Plan Transportation Analysis, there was one conducted on different roadways and segments evaluating existing facilities and travel characteristics, as well as the potential impacts and road capacities needed for a 5-year build-out plan. The review of the area shows that various transportation improvements are planned near the DSAP, including capacity expansions on Highway 29. The property is located on the west side of Highway 29 along Harvest Hill Road. And again, any future development proposed would be required to have a formal submittal, review, and approval through the site plan. Recreation and open space. The mixed-use suburban land use category allows for retail sales, services, and recreation as permitted uses. The county does not have a level of service standards for recreation, but any development could create usable, accessible, and open space that would contribute to the overall interconnectivity of a development. For the public schools, based on the public schools, Escambia County, the assigned schools, as was mentioned, is Jim Allen, Ransom, and Tate. The school district provided a courtesy review which demonstrates capacity wouldn't be exceeded using the calculations for residential development on the 1.76 plus or minus acres. Once plans are submitted, this will be reviewed, and if the need arises, there may be adjustment made to the school zone boundaries to balance the capacity among the schools. And the wellheads, it was said this was not in a wellhead protection area. Historical sites, the applicant did provide documentation stating there was no previously recorded historical resources within this parcel. The natural environment, as stated in the sector plan, the natural resources, it contains significant wetlands that are regulated by the state, federal and local governments, and the final design was to avoid and minimize wetland impacts to the greatest extent possible. There are no hydric soils on the site, and when a project is submitted, an environmental study will be necessary. For comp plan requirements, the components of the sector plan include aspects such as community design, environmental analysis, transportation guidance, and economic development principles. The land use plan and the development program provides a specific data with development program calculations and assigns permissible densities and intensities for the various uses. The parcel is north of Well Line Road in the Jacks Branch DSAP with access via the Harvest Hill. It's in the conservation neighborhood. If approved, the request removal of the parcel from the sector plan would not create a fragmented DSAP. So the applicant's parcel is approximately 1.79 plus or minus acres, and it's located in the Jacks Branch DSAP as under JB 52. Based on these calculations, the data from section 2.02, the document, the total developable acres on the entire site for the sector plan is 8,611.80. The applicant's parcel represents 0.02 of the existing developable acres. So this is the 13th opt-out that's been submitted and processed by county. And the approval, the total opt-out sector plan aggregate acres would be 458.25. So the original sector plan profile, it identified the 15,000 acres of land, the availability of infrastructures and public services, and the protection of natural resources. The calculations used to complete the maximum development scenario for the plan, they were specific and resulted in a balanced job-to-housing ratio. Changes to or the variations of any original data used would hinder the balance of the viability of the sector plan goals. So the maximum, the DSAP area would provide approximately 27,145 jobs. When analyzed using the maximum residential build-out of 23,000 dwelling units, the results of the job to employee residence ratio is 1.18. And it would be noted that there is no single perfect ratio. It's generally considered to be balanced if it has a job to housing ratio of roughly 0.8 to 1.2. If this proposed amendment is approved, the resulting job to housing ratio is 1.26. And then the existing transportation infrastructure, our traffic and transportation department did a letter, and we stated their findings in here that basically stated that there are paved shoulders. It mentioned there's the right-of-way width is 200 feet, and they talk about the Harvest Hill was number of lanes 2, paved shoulders no. And they also stated that they had no capacity concerns in the vicinity of the subject parcel. Connections to Harvest Hill will likely require improvements to Harvest Hill. Potential improvements will be vetted through the development review process by Escambia County and the Florida Department of Transportation. The underlying zoning and the compatibility with the surrounding DSAP land use designation. The existing parcel is currently zoned heavy commercial and light industrial. Surrounding parcels are zoned HCLI and LDR. If removed from the sector plan, and I listed the following ranges of permitted uses are allowed, and I won't go over these. It's just everything that's allowed in the HCLI zoning district. Consistency of any requested future land use designation with the underlying zoning. So the requested mixed-use suburban future land use, it will be consistent with the underlying zoning and uses and intensities allowed with the HCLI. And also keep in mind that the mixed-use suburban does sever the heavy industrial uses from the HCLI zoning. So before the adoption of the DSAP, the 2020 future land use designation was AA15, and with the adoption of the 2030 FLU, it was mixed-use suburban. And that's why the actual applicant is asking to go back to the mixed-use suburban. So before adopting the Midwest Sector Plan, the parcel was zoned GBD with the future land use of AA15. The GBD district was intended to enhance specific segments of Highway 29 as a visually attractive and well-planned business community. The old GBD zoning had limited intense uses, allowing C1 and C2 uses in a business type of development with extensive landscaping and buffering standards. With the adoption of the DSAP, the commercial development rights for the parcel were decreased. The adoption of the sector plan and the assignment of the conservation neighborhood under the DSAP allowed a maximum of 3 dwelling units per acre. And according to the historical document, there appears to be no residential density allowed in the previous GBD zoning. If approved, any future development associated with these parcels will be evaluated by the Development Review Committee using the current zoning regulations and addressing and minimizing any potential impacts of the proposed development. It could have any characteristics of the existing residential development. If approved, the sector plan boundary map would be adjusted accordingly to reflect the removal of the parcels from the plan. And then, if approved, the parcel would be assigned the future land use mixed-use suburban as requested. And that's the staff's analysis.
Board, are there any questions for staff at this time?
Sorry, Allison. On the zoning map, if we go to that, are any of those parcels opt-outs?
Can you specify what you mean?
Within the
Parcels.
circle, are any of those been opt-outs
Of
of the previous 15?
Yeah, let's look at the.
No, I'm talking
DC
was that a thought?
I think that's A.
20
Let's look at a different map, because that might be clearer. Because
How about the flu map, maybe that'll,
yeah, we have one that has a DSAP, I think. So that one right there where the cursor is, where it's white, it was actually removed from the sector plan. And then, yes. So anything that's white over there was actually opted out.
anything white,
So
west
one-
of 29?
Yes. North
Okay.
of that parcel.
Plus the parcel that we just talked about with Neil, which was within that big 2,500 mile, that 2,500 circle is also opted out. So it's up a little bit higher.
So just a 2 on that map?
Yes, sir.
Thank you.
Are there any further questions? All right, if not, we've got one speaker, Jacqueline Rogers, if you'll come on up. I think we've got your name and your address down for today, so we'll spare you that.
I might have forgot it, but I just want you to note that this will be HCLI and MUS, but we couldn't have that before. Remember, that's what they told you. So this is a comp plan amendment, which requires a sector plan opt-out is a comprehensive plan amendment, which requires competent data and analysis. Yet if you look through this, there's so much that is deferred until later, until the development review. And you're not supposed to be changing the future land use without this data and analysis. If you look at that one, look at the map, there's all LDL, conservation neighborhood, they're not opted out. They're 3 dwelling units per acre, they prevent commercial, they have standards of, that are good for the neighborhood. As you piecemeal these pieces out, you are creating incompatible. You can't say, well, there might be HCLI zoning underneath. They're not gonna opt out. There's a lot of homes over there. If you look at the aerial view, you'll see this is a very residential area. So when you look at the analysis, they said, okay, well, Highway 29 is, but how about Harvest Hill? That's a very small road. You saw the pictures of it. It's a very country road. So there's no there's 2 lanes, there's no shoulders. It's inadequate to go from 3 dwelling units per acre to 25 dwelling units per acre. And the staff did not show you competent substantial evidence that that's planned. It's not planned. They didn't say that. I'm going to go through my notes real quick. The current owner bought it in the sector plan. So are we going to go back to the development rights when DeLuna came and say, they have a property rights. They can put whatever they want in there. He wants to put his shell dump there, you know. This is crazy. When is a plan in Escambia County, a master plan, an OLF master plan? Are you going to allow people in Beulah to say, well, at one time this property, it was way before I bought it, allow this? No, this is what planning is. You cannot land bank property, and that's what this is happening. It's not. This is the 13th opt-out. Ask the staff how many have opted out of any other land use category besides conservation neighborhood. The answer will be none. This was a bait and switch. You spent $1 million on this. This same staff, maybe not these members, Escambia County took the data and analysis to the state and said, this is where the conservation neighborhood area should be because, look, there's wetlands nearby and it drains into the Jack Sprance Basin. But now all of a sudden that magically goes away and now the staff is saying, oh, there's no problem. Where is the environmental review to change this? It's not here. They're going to defer it into a closed process that these citizens can't get into unless you really, really, really want to sift through emails. There is no initial development review, and I'll talk about that later in public forum. The analysis talks about the DSAP. You talk about the DSAP as your proof, but you're opting out of the DSAP. In the analysis for potable water, it talks about the DSAP figures, but you're opting out of that. You're going up to 25 units per acre. And I don't believe there's a full analysis up to the maximum development. And I've heard Mr. Ingwell ask, and you guys are going to have to require the maximum, the data and analysis has to be for what you are approving, which is 25 dwelling units per acre. They can say they're going to put whatever properties change hands. You guys know that. The data and analysis is not there. I could say more if you have any questions, but it's getting old. It's getting old. We're not planning. We're just, unplanning whenever we feel like it when a developer asks.
Board, if you did have questions for Ms. Rogers, we'll allow for that, but if there are none, we'll take questions for staff or the applicant still at this time. And then if there's none of that, then I will accept a motion for this public hearing.
I move to accept OSP 2024-02.
All right, I've got a motion on the table. Does that motion have a second?
Second.
All right, is there any discussion? All right, motion is to approve the opt-out for case OSP 2024-02 with a second. No discussion. All those in favor, please signify by raising your right hand. All those opposed, motion carries 5-1. All right, do we have any other action items or discussion items? No. Was that a no? That's next. I got you. I'm with you. Jacqueline, if you want to come up for public forum.
Real quickly, I want to challenge any of you guys. Have you ever been to the development review? Have you ever gone to the meetings? The initial development review? Have you gone to that? Because it's not public. You may have gone as a developer, but have you gone as the public? I used to go. I went with Teresa Blackwell before. I went another time. But if you look on the agenda now, it says initial application is not open to the public. So I want you guys to think about that when you're telling people up here, you can deal with the traffic, you can deal with this in development review. No, you can't, because they're not letting now. You can get the emails, you can do public records requests, you can try and go on My Government Online, which I have a hard time figuring it out. And I'm pretty handy with the computer. So most people aren't going to be able to do that. What's the next process? You have pre-application. That's not even required, okay? That's the first part. So you might go to a pre-application and catch it, but a lot of people just skip that part because you don't have to do it. Initial application, it's not a public meeting. What's the next meeting listed on the agenda? Because I post these on Escambia Citizens Watch. What's the next one? Final. Well, you know by the time it gets to final application, it's pretty far down the road. And even the big sector plan opt-out behind me, I couldn't even follow it because, we have lives, we have business, busy schedules just like you guys. It's not public friendly. You can't change that, or you could suggest it, talk to your commissioner, but please don't defer people to development review because Unless you've gone to it lately, staff's here, they can verify, is the initial application process open to the public, that meeting?
There's no meeting that's actually had. We issue comments to the applicant.
Right, so there's nothing, so when would the public get involved in the development review process?
There's public that sits in the pre-app, essentially.
But do you have to do a pre-app to do a development?
You don't have to, but it's highly encouraged.
Right, but some people don't. Some developments don't come, so how would somebody give input? How would the citizens that are here, when you guys say you can give all this input at development review, when would they do that, if they don't go to pre-app?
I would say in my experience, they usually reach out to us via staff, whether it's, sitting down with staff members and looking over the plans and seeing what's proposed and stuff.
So, how would they know to do that? So I'm just, the process is not friendly. It used to be open. I don't know why the initial application is no longer open where the public could hear about it.
So Jacqueline, I actually raised that same kind of concern recently with some of our elected officials, and I will say I agree with you. There should be transparency on the DRC levels, and honestly, involving the public with it is another layer, just like when we did the notifications for certain developments, to planning. But I do agree that that level should be more transparent and should have the ability, because every time we have people coming up to this board with comments and concerns that are really geared for really the DRC process and not for this board. So I will always say that. And that's why I always defer it, but I agree. No, it needs to be more open and transparent, and I think that's something that should happen soon.
And some people, their concerns might go away. They might say, oh, look, you addressed it. That's fine, so. Also, I really would ask you to go back and read that section with the 5 criteria, go down past the mobile home little part and go finish that section. And it does say that even if a developer meets all those criteria, if it has adverse impacts, you guys are allowed to deny it. And you did today, so I appreciate that. Thank you very much.
And I'll just say to
Jacqueline,
that, Jacqueline and Jay, I'll let you speak too, but, I brought that up a few months back. I can't remember when, and I know that you have as well. And I think we can all read up here, and I read it the same way you do.
It should be in
And
the
we
hand-
haven't
it
been
should be
able
in
to
the
get an
handout.
answer from staff on, in my opinion, a real good, solid answer on how we are to utilize that in this process. And so it's kind of just left up to us as board members, how we utilize that in our argument or motion. So I do understand that, and to me, it's plain as day on what it says. Anybody else can comment on that if they'd like.
If I could just ask that handout be changed, because it stops right at, the 5 criteria, and then it doesn't put that in there, so no one else knows that, and so that they could speak to it. I know we can all get up here and say our property values have, are diminished, and that's not adequate because we have to have studies to show that. I understand that, but there are some things that you guys, it's a judgment call, and I appreciate the time that you guys put in. It's a judgment call, and you guys know in the county commission, it's a judgment call, sending it back and things like that. So I don't know, but thank you for acknowledging that. And I did see that meeting. I do watch the meetings. I have a 91-year-old mother, so it takes me great pains to come here. This is my neighborhood. I'm not just being nosy. The 2 I spoke about today were my neighborhood, so that's why I was here. So, thanks.
If you, it's public forum.
Just
Yeah.
real quick, because I had to take the day off work to come. And this is the second meeting that I've attended. I only have 6 days that I can take off. So whenever we have something that we care about, and it's happened a lot, all of these properties are around us. I was over here in July for one that's very near and dear to me. And it's hard to get to them at 8:30 in the morning. I had to take the full day off. I couldn't even take a half day off. I had to have a substitute
So do we.
teacher. I have to.
We have to as well.
Right. So we need, but this is. Well, yes, and that's a problem. It needs to be available to the public. This is not available to the public. I mean, there's a lot of people in my neighborhood who care very much about what's going on who can't make these meetings. And I certainly can't make every single one of them. I mean, I have 6 days, that's it. So
What's your recommendation?
it needs to be done after work. People can't take off work. I mean, most people don't get paid. And for me to take off work, it's a big ordeal. I'm a teacher. I mean, I have 20 kids that have a substitute teacher today because I had to come to this meeting. So, and it's very arbitrary. It's not like, I mean, it's like you have to be there on this date. So, I also would suggest being able to attend in a different way. I mean, you can do court cases now via Zoom and that sort of thing. I just think it needs to be, these are big decisions being made. And a lot of people seem to think if you're not here, you don't care, and that's just not the truth. So, those are my thoughts. All right, thank you.
Thank you. All right. Yes, sir. Okay. Our next meeting is December 3rd, and I think that wraps it up.
Could I make an
Yeah,
announcement?
if you would.
This is my last board meeting sitting on this side. I'd like to thank Commissioner Burgash for appointing me, my fellow board members. We didn't always agree, but I respect your opinions, and I've learned a lot from each and every one of you. Staff, Allison's really happy I'm leaving because of all the questions I ask. But I appreciate the work that you all put in. Whenever I had a question, you'd have an answer, so I appreciate that. The citizens, for those of you that show up and participate, that's what it's all about. So I thank you all. I thank my wife and my daughter for putting up with the time I prepped for this, and Jesus Christ, our master planner. So, thank you.
Thank you, Jay. You've done a great job, and I think, hate to see you go. I know sometimes it's out of your hands, but it's a loss to this board and this community, but you've done a great job while sitting up here, so. All right, we are adjourned.